of the Committee on Housing and Executive Administration. The time is 12:05 p.m. on Thursday, the 20th of May, 2021. We are meeting remotely via Zoom to hold a roundtable on the following measures. 24-96, the Eviction Record Sealing Authority Amendment Act of 2021, and 24-106, the Fair Tenant Screening Act of 2021. This hearing is quite timely as our vaccination numbers are rising and COVID cases are declining. The end of the pandemic is inevitably approaching. While these trends signify a long anticipated return to normal, it also means that the social programs and protections enacted by the government will soon expire. I'm very concerned about the district's housing landscape in the coming months. Many of our residents lost their jobs. Many have not worked for over a year and have not fully returned to pandemic employment. Unemployment insurance and the eviction moratorium have been lifelines to these residents and to those who depend upon them. The district has worked to prevent worst case housing scenarios for tenants most at risk by offering a number of rental assistance programs since last summer, including expanding ERAP, the Emergency Rental Assistance Program, instituting CHAP, the COVID Housing Assistance Program, and now the Stay DC program, which offers tenants and landlords 1 year's back rent and 3 months future rent. The district must spend 65% of the $200 million of this funding by September 30th or forfeit the remaining 35% of the funding. As wonderful as these programs are, and as urgently, I therefore have to encourage residents to please take advantage of the Stay DC. It is a fact that these programs and protections will end eventually. So we want to take advantage of these programs. And I know that I've heard as recently as this morning that the process can take 45 minutes. Well, I know that there are documents that we are requiring, documents that the Department of Treasury requires. So I just ask the public to bear with us, but most importantly, get the help that you need. So, eviction is a life altering experience that we all can identify with in one way or the other. And while we cannot force residents to accept rental assistance, we can ensure that those who do receive eviction filings are afforded protections that are appropriate for a new post pandemic world. We can give them tools to ensure that they don't have a permanent mark on their record and that threatens their housing stability far into the future. DC has a challenging and is a challenging place to live and thrive for many people before, and a thriving place for people before the pandemic. Many tenants will continue to face hardships, however, but temporary hardships should not put a permanent mark on a person's record. The two bills we are examining today will ensure that a temporary hardship does not put a lasting stain and strain on any tenant's record. Bill 24-96, the Eviction Record Sealing Authority Amendment Act, was introduced by, co-introduced really by Council Members Shea and Allen. Many of its provisions are currently in effect under emergency legislation. Renters who face housing insecurity cite the existence of an eviction claim on their record as a factor that makes it nearly impossible to secure affordable and safe housing. Prior to the emergency legislation, an eviction filing could remain on a tenant's record forever. even if a judge dismissed the landlord's claim or if a judge found in favor of the tenant. The presence of an eviction filing on a tenant's record says nothing about the character or long-term financial means of a tenant. Before the eviction moratorium, landlords filed claims for non-payment of rent, but also filed retaliatory eviction claims for reporting unsafe housing conditions and for minor amounts of back rent, according to a recent Georgetown University study. Most eviction filings are concentrated in wards 7 and 8. Across the city, only 5.5% of eviction filings in 2018 resulted in an actual judgment in favor of the landlord. The only thing that an eviction filing verifiably says is that a landlord decided to file an eviction claim against that tenant. This legislation provides a remedy for all who interact with landlord-tenant court. It provides Superior Court with the ability to seal eviction records in specific circumstances. The legislation requires that the seal eviction records after 30 days when a landlord's claim was not decided in favor of the landlord. It requires the court to seal all eviction records after 3 years and authorizes the court to seal certain eviction records upon motion by the defendant. Finally, the legislation would amend the district's Human Rights Act to prohibit landlords from taking adverse action against a prospective tenant for having a sealed eviction record and to prohibit landlords from requiring that a prospective tenant disclose a sealed eviction record as a condition of housing. Bill 24-106, the Fair Tenant Screening Act of 2021, was introduced by Council members White, Nadeau, and Gray. It amends the DC Human Rights Act of 1977 to prohibit housing providers from inquiring into the source of income and credit history of a prospective tenant, to require housing providers to notify prospective tenants of specific information before collecting any application fee, and to strengthen penalties for offenders. The new provisions include the following. A landlord must provide a prospective tenant with the monthly rate for all available units, including information stating whether water, electricity, gas, and any included rent rate that requires the landlord to inform an applicant of the final determination of their application in a certain amount of time. It grants to the applicant the right to dispute the accuracy of the information the landlord obtained from the third parties in their evaluation of an application, and mandates a timeline for the landlord providing that information to the applicant. And it adds protections for applicants using housing assistance vouchers and restricts the information that background reports may include about a prospective tenant. And finally, requires screening companies to cite to the source of the information, including in background screening reports. Many landlords in the district already provide much of this information to prospective applicants on their websites or in written materials, and this kind of transparency and forthrightness is commendable. The provision of this bill would assist tenants in making informed housing choices, allow them to ensure that the picture that a third-party background screening company paints of their background reflects the truth and holds the landlord to a consistent standard of transparency across the district. However, concerns have been raised by the committee about the bill amending the Human Rights Act. I look forward to hearing from our government witnesses about placing the provisions under the Human Rights Act, or should it be under the Rental Housing Act. At this time, I recognize I have at least one of my colleagues that has joined us, And I'll ask Councilmember Silverman if she would like to make an opening statement.
Yes, good afternoon. Good afternoon, Chairwoman Bonds. Good to see you. And good afternoon to everyone at this hearing virtually. I do want to just make a maybe 2-minute opening statement, Council Member.
Oh, yes, please go right ahead.
Thank you. Thank you so much. So the bills before us today, as well as a related bill I think we'll be discussing next week, strive to improve residents' capacity to be treated fairly in rental applications while allowing rental owners to screen out tenants who do pose legitimate risks to their rental communities. It's incredibly important for the district to get this balance right. If we don't allow reasonable tenant screening, then property managers can't provide great communities for district renters. But if we allow everything about a tenant's background to be considered, then rental property owners will screen out a lot of good tenants, I think. And worst of all, they can inadvertently fall into the trap of screening tenants in racially and inequitable ways. And we have stated as a council that racial equity is going to be one of the foundations of how we evaluate public policy. A long history of racial inequity means even when there's no cause, the district's Black residents are more likely to have an eviction or arrest record than white residents. And that's even if the eviction case or arrest goes nowhere. Yet we allow unproven and unfounded allegations to be the basis for denying someone a home. And this fails the racial equity test, and we clearly need to change this. I have started resuming something that I used to do, which is to sort of preview the witnesses on the things that I'm interested in so they can speak to it in their testimony. It'd be really helpful. So the questions I have are, do the bills before us advance racial equity in rental markets? Do the bills allow rental communities to set and hold clear but fair emphasis on fair standards for residency? And did the bills give the government and those working in the public interest sufficient access to information to track inequities in the courts and rental markets so we can see where there might be problems? That's all I have to say, Councilmember Bonds. I look forward to the hearing. I am toggling between a few different things and have like 2 computer screens and confusing myself at this point, but I will try to pay attention as much as possible for the hearing.
Thank you. Thank you very much, Councilwoman. You are right. We have a lot of competing interests today. So I will mush forward with our hearing, our housing hearing, and look to you and others to take care of judiciary and a couple of other things that are going on. Thank you very much for joining us. So at this time, we will begin to hear from our public witnesses. And I'll ask the staff to call our first panel. I think we had a few changes, so I will look to you to call the panelists team.
Hello, Councilmember. Can you hear me now?
Yes, now
Okay,
fine.
so there we
Thank
go.
you so much.
I think coincidentally, both Gabrielle and I's audio was messing up there, but I managed to fix mine. So our first panel finally is Emily Neer, Shanetta Malkia, Dylan Fine, Dimitri McDaniel, Fritz Molhauser, and Lee Higgins. And our first witness is Emily Neer, who is on the screen right here.
All right, well, welcome and good morning, afternoon. Some of you have been here, I think, a few minutes early, so thank you very much for that. And the floor is now yours. You will each have, I think it's 3 minutes to make a presentation to us on these two bills. So Ms. Neer, we'll start with you.
Good afternoon. My name is Emily Neer. I am a housing case manager in the housing unit at the Legal Aid Society of the District of Columbia. In my role, I support legal aid clients, many of whom have housing vouchers and identifying and applying for new housing. I am testifying today in support of the Fair Tenant Screening Act and Eviction Record Sealing Authority Amendment Act. These bills address several of the barriers tenants face when looking for new homes by implementing necessary safeguards to ensure that all district renters can find safe and affordable housing. Today, the housing application process is ambiguous and challenging. In the last year and a half, I've called several hundred landlords across the district to inquire about unit availability and eligibility criteria. I'm often met with vague, dismissive answers and a barrage of questions regarding the situation of my clients. These are likely cases of housing discrimination that are nonetheless difficult to address given the immediate pressure that my clients are under to find housing quickly. This lack of clarity makes it very difficult for prospective renters to make informed decisions on how to best navigate the housing market while seeking a new home, and provides ample cover for discriminatory practices. If denied for housing, it can be nearly impossible for a tenant to receive justification for this decision. For example, a legal aid client I work with, who I will call Ms. Monroe, is a Housing Choice Voucher Program participant who I assisted with locating a new home last year. After several months of attending viewings, Ms. Monroe found a house in Northeast DC that was perfect for her and her family. Unfortunately, less than 24 hours after submitting her application, she learned that she was denied, though the reason was unclear. We requested more information about this denial, but were directed to contact a background screening company as they held her background report and credit report. After several calls to the screening company and requests for assistance to the management company, Ms. Monroe decided that she simply could not commit any additional time or energy to track this information down and opted to drop it, thus giving up her opportunity to rent this home. By requiring landlords to provide an applicant with specific grounds for decision and any associated third-party literature they attained, tenants like Ms. Monroe will be better equipped to challenge erroneous or improper denials. And the requirement of an appeal period as established by the Fair Tenant Screening Act will make this possible. This also makes it more difficult for landlords and tenant screeners to covertly engage in discriminatory practices during the rental application process. For voucher holders, source of income discrimination compounds the difficulty of housing search process. While this form of discrimination is illegal in the district, the lack of transparency in the application process allows landlords to discriminate without ever being caught. The Fair Tenant Screening Act would strengthen protections for voucher holders specifically, providing them with more opportunity to choose the homes and neighborhoods they wish to move to. The Eviction Record Sealing Authority Amendment Act also would make navigating the housing search process significantly easier for tenants who have a history of eviction cases. Eviction filings can prevent qualified tenants from securing housing, regardless of the merit of the filing or outcome of the case. Landlords will frequently deny tenants housing due to a single eviction filing, which can lead to tenants being denied access to entire communities due to an allegation that was not true. We do believe that a very narrow carve out to this robust sealing system proposed in the Eviction Record Sealing Act is needed. This carve out would allow for tenant serving attorneys to access sealed records, and our attorneys would be happy to discuss this further. We believe that the Fair Tenant Screening Act and Eviction Record Sealing Authority Amendment Act will protect district residents as they seek to recover from the COVID-19 pandemic. Thank you for the opportunity to testify today.
Thank you for your testimony. Our next witness.
Our next public witness will be Shanetta Malkia.
Good morning. Well, good afternoon, everyone. Thank you so much for your time and hearing me out. My name is Shanetta Malkia. I am the CEO for the PMs of the City. We are a full service property management company serving Maryland and DC constituents. I've been a property manager in DC for over 22 years, and I thank you all for taking the time to listen to small landlords again. I am very much against both of these bills because you're trying to blindside landlords. I'm listening to Emily. Emily didn't call me about affordable housing when looking for clients because she would have found it. I will agree that it's very difficult for residents to find housing, affordable housing in the district, but that's because the district has made it very difficult. During the pandemic, we have lost so much potential and even be able to speak to residents and communicate with them to find out what their situations are. You sealing the evictions for residents gives us a false perception as to who we're taking into our communities. It's just like a job application, or you're applying to buy a house. We need to understand that, one, that they can afford the rent. There are standard practices. So every management company should have a standard application process that is given to all applicants at the beginning, so they know exactly how much the rent is. They know exactly what the requirements are. They know exactly how to apply. Now, if that is not happening, that needs to be addressed. But there is no reason that a landlord should be blindly given an application, or a resident should be able to submit an application without submitting all of the proper documentation so we know who we're dealing with. There is no one eviction and you're out. Evictions are on your report because there's a formal judgment. If there's no judgment, it tells you that there is no judgment, and that should be removed after 3 years. But if a person is bouncing from community to community and leaving tens and 15 thousands of money on the table that they owe a landlord, and a landlord is subject to losing their property because you, legal aid and other tenant advocacy, have yet to show people how to budget and properly obtain their responsibility to a legal document that they signed. We all have to sign lease agreements. We all have to uphold our part to rent. So we, as small landlords, we can't afford to have somebody move into our property, a 1-unit home, and lose 5 months of rent, while we go to district court, where we have not been able to file for over a year, where we have not been able to pay mortgages, where we have not been able to properly take care of our properties, and with the health and safety concerns of the individuals that are coming in. Yes, we are suffering in Ward 7 and 8, landlords and tenants alike. Make a decision to reject both of these bills, be transparent with both of your constituents, and develop programs that are more effective to make sure your tenants have the tools they need to be successful. We provide 40% of the housing in the District of Columbia. If you want affordable housing, be realistic, stop beating up the landlords, and be here to support us. We've taken enough. Thank you for your time this afternoon, and I do hope that you take this in consideration.
Thank you for your testimony. Our next witness.
Our next witness will be Dylan Fine.
Hi, my name is Dylan Fine, and I'm an intern at DC Voters for Animals. First off, thank you for allowing me to speak today on a topic that is as crucial as ever in 2021. DC Voters for Animals is an advocacy group dedicated to lifting up the policies and the politicians doing the most for animals, whether it's companion animals such as cats and dogs, animals in farms and labs, or wildlife. We, Law DC Council, and the Housing Committee, we're coming up with strategies to increase access to stable housing, strategies that will help some of the most vulnerable DC residents and our companion animals in this time of need. As such, we support both the Eviction Record Sealing Act, Sealing Authority Amendment Act of 2021, and the Fair Tenant Screening Act of 2021. Stable housing is particularly elusive to low-income people with pets. In fact, approximately 20,000 district tenants in DC public housing are prohibited from having pets in their homes. While fair housing laws protect individuals with disabilities that utilize service and assistant animals, pet owners are not granted vital protection from housing providers who threaten to or file an eviction claim in bad faith. And a lack of stable housing has a severe effect on both individual and public health, increasing the chances of COVID-19 being contracted by about 50%, which therefore puts the public at risk if this individual is out on the street. In addition, regardless of whether a pet is a service or assistant animal, it can have a tremendous impact on one's well-being. Over 70% of pet guardians identified their animals as essential towards their mental well-being, and the pandemic has taken a toll on mental health overall. DC saw a 17% increase in mental health services between 2019 to 2020. Yet, only 44% of housing providers in DC allow pets, and 30% of US pet relinquishments to animal shelters stem from housing issues. And because of this trend, you may encounter, as I do when walking through our beautiful capital, people experiencing homelessness who live with pets far too often because of instances that force people to have to choose between shelter or their beloved companions. There shouldn't have to be a choice in this situation. The benefits of the Eviction Record Sealing Authority Amendment Act of 2021 and the Fair Tenant Screening Act of 2021 will be felt by pet guardians who live under the threat of unstable housing. These measures will give those with pets a better chance of bouncing back from an eviction or landing in stable housing at a time of need. We at DC Voters for Animals appreciate these efforts to protect tenants, especially those of animals, and welcome policies like this one to make DC a more livable city for those with companion animals. Thank you for letting me speak today.
Thank you very much for your testimony. And I believe our next witness is Mr. or Ms. McDaniel.
Hi, my name is Dimitri McDaniel. I'm with
All
Brent
right.
for the City.
How are you?
Good. How are you? Thanks for letting me provide testimony today. I'm a staff attorney with Bread for the City, a 47-year-old direct services nonprofit offering food, medical, legal, and social services to roughly 30,000 district residents living on low incomes. Bread for the City is part of a legal service network that provides free legal representation to thousands of low-income district residents in landlord-tenant court each year. I'm providing testimony today in support of the Eviction Record Sealing Act and the Fair Tenant Screening Act, but I will be focusing on the Fair Tenant Screening Act, which creates permanent, common sense housing application screening standards for DC landlords. Speaking on behalf of Bread for the City, I'm going to focus on how this bill specifically benefits low-income tenants given the discrimination and indignity they regularly face during the housing application process, the eviction process, and within our criminal justice system. The clients that we serve are predominantly Black and brown and face systemic and persistent discrimination wholly because of their race, ethnicity, and financial situation. By passing the Fair Tenant Screening Act, Council will be acknowledging and starting to correct many of the wrongs that Black and brown people face when they engage and interact with many of our systems and institutions of authority. First, I want to focus on how the Fair Tenant Screening Act makes it a requirement for landlords to disclose upfront many of the criteria that they use to accept or reject prospective tenant applications. This is important because these types of disclosures must occur before the applicant provides the prospective landlord with any type of payment, like an application or holding fee. This is crucial for low-income tenants who are often drawing from extremely limited financial resources in their housing search. Secondly, the Fair Tenant Screening Act will address rampant source of income discrimination that continues to block and punish our low-income residents from safe and clean residences. Building on the protections in the Fairness in Renting Act, the Fair Tenant Screening Act also prohibits landlords from denying subsidized tenants applications for failing to meet an income or credit score threshold. Using income or credit scores to deny voucher holders has long been recognized in DC and nationally as a thinly veiled source of income discrimination. Thirdly, the Fair Tenant Screening Act serves as a necessary backstop for many of the protections, as both council members have mentioned earlier, that we already have in DC. With the proliferation of eviction records being sealed, one may think that a sealed eviction would not show up on a screening report. Unfortunately, many of these background screening companies are wily and they scrounge and capture information provided in public records without ensuring the record is accurate and without investigating the particular surrounding a criminal or court eviction record. This means that many tenants are impacted by these records, even though these records are as far back as 10 years, and they don't really impact how a tenant's future renting history may turn out. I also want to point out, while my time is short, that though we're in support of the bill, Bread for the City does believe that the Fair Tenant Screening Act could be improved by placing the burden on complying with the law on the landlord rather than the background screening companies. The current structure of the Fair Tenant Screening Act places the burden on the background screening companies to not include certain information in the reports that they generate for landlords. This leaves a broad and deep hole within the current legislation, as some companies are more reputable than others. Instead, it is our suggestion that the burden shifts from these unknown out-of-state companies to our local landlords. With this restructuring, the landlords would be the ones to evaluate the reports generated by the background screening companies. They will evaluate any risk and score recommendations, will consider additional information, and will be the ones making the final decisions to deny or approve prospective tenants. Under the burden shifting plan that we're offering today, a number of legal service providers are advocating for. If a landlord denies an application after receiving a screening report from one of these background screening companies, then there would be a rebuttable presumption that the landlord used inappropriate records included in the screening report to deny the applicant. This burden shifting mechanism is currently used in New York and is being discussed in Connecticut as a possible change to their tenant screening laws. This also will provide a certain amount of enforcement power to the Office of Attorney General to pursue civil claims, which does not exist under the current version of the Fair Tenant Screening Act. I want to also mention that in the New York law and in the Connecticut legislation, the Attorney General's enforcement will still be in connection with the Office of Human Rights, who will propagate the rules with regards to this act. We believe that this actually creates a more workable solution and will allow for landlords to have their ability to review this information. And then if it is true that there's something that the landlord sees in the screening report, the landlord can then come forward and defend their decision for denying an applicant. So I want to thank everyone for their time, and thank you for letting me speak to both bills. And I want to reiterate that Bread for the City supports the passage of both legislations.
Thank you, Mr. McDaniel. And I'm assuming that we have a copy of your testimony.
You will be receiving a copy. It's a little bit longer, so I didn't want to take up too much time. I know you have a long day ahead of you.
All right. Well, please make sure we get a copy of it. Thank you very much. I want to make sure we capture those perspectives that you were sharing with us. Thank you very much.
Absolutely. Thank you.
And I think our next witness is Mr. Mulholber.
Thank you very much, Council Member and Council Member Silverman. I'm Fritz Mulhauser. I'm the co-chair of the legal committee of the board of the DC Open Government Coalition. I'm a 50-year DC resident and a civil rights attorney. Our organization's been active for a dozen or more years in all aspects of advocacy for open government records. We're here to speak about Bill 24-96, the record sealing bill only, and we're asking you to be sure to amend it before final passage to preserve a valid public access to court records, which serve such crucial purposes. Of course, there's misuse of court records. The research is clear, the anecdotes are powerful. Landlords grasp at any shreds of information to address their sense of risk in making tenancy decisions. Senator Elizabeth Warren just a few weeks ago wrote again with 5 other senators to the Consumer Protection Bureau asking, please investigate these technology companies that are peddling such shaky information, which is badly used. The other bill addresses the demand side, the users, and it's a good step to give them guidance on the criteria and data that they can use. But look, sealing laws need to be thought of in a broader context. The sealing of the records in this bill will leave no public data to evaluate the busiest segment of the DC courts. The landlord-tenant branch has over 30,000 cases filed a year. We need to be able to follow what's going on there. The research the council itself has relied on to do its work is presently impossible because of the temporary legislation and will be forever impossible if this bill goes forward without amendment. The courts today are turning away researchers who are eager to do the work that you rely on. The Rosen and McCabe study that's been cited so many times that tells us how many cases settle without adjudication. That work will forever be impossible to follow up. It was cited in your own opening statement. That work will be impossible. The work of Josh Kaplan, a diligent reporter that's shown light on sewer service where tenants default in their cases because the process server tosses the papers in the basket and never serves them. That work required a year of study of court records. It would be impossible to do today Yet the council changed the law in a few days after reading his important findings. Please amend the bill to authorize the court to allow access upon a proper process and safeguards. Without that explicit access authorized by you, the court will go on doing what it's doing today, which is to turn away every researcher who asks for data because the council has told them to. Professor McCabe will be with you later, and I encourage you to ask him a lot of questions. He's the expert on research access, but he'll say it perfectly plainly. He'll say, if you continue with this bill without amendment, you will hurt tenants because you will lose the information that you need to make sound policy and that you have already relied on to make sound policy. No other statute provides access. There is no coverage by the Freedom of Information Act, any other. Only your bill is setting the ground rules. And I don't think you want to go forward flying blind without data. Our coalition has proposed some language. It was proposed by tenant advocates in Massachusetts. It's pending before that state legislature. The tenant advocates there find no conflict with a properly designed public access provision. Please look at our language. We look forward to working with you on any sort of language that would do this. But as I said, please ask Professor McCabe about it in detail, but you will be flying blind if you cut off access to the data, as this bill will do. Thanks so much.
Thank you very much for your pretty powerful statement there, Mr. Milhauser. Thank you very much. I think our next witness is, I believe, Ms. Higgins. Okay.
Good afternoon. My name is Lee Higgins. I am a senior attorney at the DC Tenants' Rights Center. We are a small private law firm that helps district tenants with issues including eviction, lease termination, repairs, security deposits, TOPA, and rent control. Thank you, Madam Chair, for calling for this hearing today. We support both of today's bills and have some suggestions for reconciling them with the Eviction Protections and Tenant Screening Act, as well as some proposed changes to these three bills. And just to reassure you, I have sent this testimony by email, so don't worry about capturing all the details. I'm going to go through them fairly quickly. So today's two bills work well together, and we do urge the council to pass them together. So first, tenants are already seeing the positive impacts from the temporary Fairness in Renting Act, and we applaud the council for moving to make some of these protections permanent, especially the provisions regarding ceiling cases and requiring notice before filing non-payment of rent eviction cases. However, none of the proposed permanent bills address the problems with service by posting. Sewer service is a completely avoidable problem and should not be permissible once the eviction moratorium is lifted. Josh Kaplan's well-researched article from 2020 shows how hard it was for individual tenants to spot the patterns of the apparently fraudulent service and how easily technology could help prevent this problem in the future. So if this provision was important enough to pass during the public health emergency after that article was released, it should be kept once eviction filings resume. That's when it will really be needed. Landlords should be required to take pictures when they post complaints on tenants' doors and provide that proof to the court. It's really easy to do. We support the Eviction Record Sealing Act today and also propose an additional provision, as Mr. Mulhauser discussed previously, to make sure that researchers and journalists who are investigating how the courts work are able to gain full access to the cases. And so we would also agree that there needs to be some type of proper and standardized application. And these users should also be required to obtain a second court approval showing the public interest that outweighs the tenant's privacy interests before being able to publish or otherwise share the sealed information. Again, Mr. Kaplan's story and the Georgetown study by Eva Rosen are two recent examples of the types of research and journalism that are really important to our understanding of the full picture of how our eviction court works. We think that the benefit to tenants of sealing the cases is hugely important, and we don't want to let that go unsaid. But systemic changes that come from research are also important. And so good data helps inform good decisions, and we shouldn't completely cut off access to that data. Further, we propose 2 more categories of cases that should be included in the list of permissible reasons to seal a case. First, temporary effects of the COVID-19 pandemic should be a reason to seal a case to help people get a fresh start. And second, we think that if both parties in a case agree to seal a case, then that should be a permissible reason as well. It makes it easier for a tenant to move out and find a new place to live as a way to settle a case if that eviction is not public. So moving on to the Fair Tenant Screening Act, we really appreciate the level of detail included in this bill and that it prohibits using court actions initiated by the tenant against previous housing providers. Tenants should be able to access the courts to protect their rights without worrying about future landlords who will deny their applications because of it. We also appreciate the provision requiring housing providers to provide the full copy of any reports obtained. This is really helpful because otherwise mistakes and inaccurate information can persist for years. The only change that we would request is to clarify that there's a private right of action that exists along with the civil penalties to help encourage prospective tenants to enforce their rights under this new bill. So we think these bills should be passed together and reconciled with the Eviction Protections and Tenant Screening Amendment Act, which includes 2 provisions that we support and would like to see included in whatever final outcome there is, and that's prohibiting eviction filings for less than $600 and also prohibiting eviction filings by housing providers who do not have a current basic business license. So with all of this together, we think that these bills will go a long way to help tenants access safe and appropriate housing in the district. Thank you for the time today.
Thank you very much to each of our witnesses today. I am looking forward to your working with us as we move these matters forward to the full council, hopefully. So thank you for your input. You're right. We will have your testimony and would like to look at your testimony thoroughly to understand the changes that you are proposing. But I do have just a couple of questions to the entire panel. We heard from one of the representatives of the Housing Providers Association concerned that both bills limit access to vital information that informs landlords as to whether or not certain financial background information should be accessed in order to determine whether or not the renter is a individual that they would like to have on their premises. That's pretty much what this boils down to. And so I wanted to get some feedback from each of you, and I'm sure Ms. Mafia will chime in and tell me what are your strong feelings about that? How should that work? What should be the very basic information that is accessible by a landlord regarding a prospective tenant? And I'll start with you, Mr. Fine. I think you're our animal rights person.
Yes. Sorry, can you repeat the question?
Okay, I just wanted to see if you had some thoughts about what are the vital pieces of information that a landlord needs to access about a prospective tenant in order to feel comfortable that this is a tenant that I want on my premises or in my building.
I think that's a question that I would need to circle back with you on that right now. I don't feel comfortable answering that question right now.
All right, well, thank you very much. Mr. McDaniel?
Yes.
Now we can hear you.
Okay, great. Yeah, I think there are already laws on the books that would allow for a landlord to seek the information that is necessary being financial records, any type of convictions under the Fair Criminal Record Screening Act, and any type of credit reports that they would actually receive from these credit reporting, background screening agencies. It is not necessary for a landlord to receive a 10-year-old eviction to determine whether or not a tenant can move forward in a tenancy, 10 years later. It is also not necessary for a landlord to receive low-level misdemeanor convictions that, resulted in innocuous fines of like $50, both of which we've seen at Bread for the City happen to our tenants. And they were actually denied tenancies due to those things, a $50 fine for a misdemeanor and 10-year-old eviction records. And you'll hear later today from some folks that will speak to that. It's not necessary for a landlord to know that. We don't necessarily have an issue with the income level piece, being able to afford a unit. But beyond that, it becomes, a lot of the information becomes less relevant and less necessary, and is used to kind of prevent low-income tenants, particularly those that are Black and brown, from being able to rent in safe and clean residences. And that's something that we think that everyone in the district should work against. And that's something that we definitely want to do, as Bread for the City is trying to do on our behalf.
Thank you very much. And Ms. Neer, are you still with us?
I am still with
Okay.
us, with you. I do want to reiterate everything that Mr. McDaniel just said. I think that he hit on several main points. I think when it comes to, reviewing a tenant's application for housing, viability to meet lease obligations is really what should be looked at in terms of, payment. I work with a number of voucher holders. Their credit scores do not reflect their ability to make rental payments. But my clients often are denied housing based on credit, even though it does not show, anything about their ability to make those payments. Additionally, when it comes to eviction record sealing, there are several, as has been expressed throughout the testimony this afternoon, several people who experience eviction filings where there is no, merit for the case. I, unfortunately wasn't able to get to it in my testimony, but one example that I do write about is a tenant who was, living in egregious housing code violations. The DC Housing Authority had stopped payments on her unit because of the housing code violations. Her landlord told her that he wanted her out of the unit in order to, fill it with a tenant who did not have a housing choice voucher and he did not have to meet certain obligations or wasn't as closely monitored. And then sued her, alleging that she had a drug haven, which was a totally baseless claim. The case was dismissed, but it's still on her record, and it has prevented her from locating housing in the neighborhood of her choice. This is the only eviction filing that she had against her. So I think when it comes to evaluating whether or not someone is a viable tenant, those are the kinds of things that need to be taken into consideration.
Thank you. Thank you very much. And I think, Ms. Higgins, you kind of touched on this, but I'll give you an opportunity to add if you would like.
Thank you. And first, I'd like to point out that Ms. Malkia stated she's in agreement that dismissed eviction cases are not useful information for future landlords. However, the fact that they exist and are so easy to find does prevent tenants from finding future housing. There are all kinds of reasons that cases are filed and dismissed. Sometimes they're completely filed mistakenly. They may have been, somebody's payment got applied to the wrong unit, or just a simple bookkeeping error on the part of the property manager. And that is something that is it's a weight, it's a burden on the tenant forever going forward, trying to find some place to rent in the district. And that's unfair. So I think that, I guess I should say, aside from the data analysis and the research perspective, there's no good reason to keep those types of cases as a part of the public record. All it does is harm tenants.
Well, thank you. Thank you very much. And Mr. Mulhauser, we know where you stand. You want things to be as public as needed, and you want to make sure that the research can move forward. But if you want to add one line on that, we'll take it. I want to be fair here today.
Thank you very much, Madam Chair. The position of someone advocating for research is often, trust me, it'll pay off. But you have the goods. You have been basing your understandings of this difficult area on the sound findings of good journalists and good scholars and others. So I think you have before you the proof of the pudding, and the devil is in the details. Let's get a way that the court is comfortable and the advocates are comfortable that we have responsible data users making responsible uses as much as you can ever predict that, and keep that data flowing. And let's wish wind beneath the wings of the senator and her colleagues who are trying to get the federal government to crack down the same way we've been on top of the credit screening industry for decades to only collect data that matters and don't be peddling snake oil. The landlord faces an enormous information problem. I get it, but they shouldn't just be able to benefit from cheap and worthless information that they claim is useful when it's really not. So this is an industry that needs a kick in the pants to be using valid information the same way you wouldn't want to assess a child based on 1 hour observation in his kindergarten class. We need to have people forced to make decisions based on sound information, and amending the bill will keep the good flow of information going to those who can make valuable uses.
Well, thank you very much. And Ms. Malkia, I have to ask you to chime in if you would like. What I'm really asking, what information is vital for the landlord to make a decision as to whether or not a tenant is suitable for that particular property?
Councilmember, it looks like Ms. Nokia dropped off, so she.
Okay, all right, okay, all right. Thank you. I can only see, now I see 5 with myself, but I'm limited in my view from this perch. So thank you all very, very much for your testimony. Please make sure we have it in writing. I believe my colleague, Councilmember Silverman, I think she dropped off a little earlier. All right, okay. So thank you all very, very much for your testimony, and we'll take the next panel.
Okay, while Sam is setting that up, I'll call the names. On panel number 2, we have Catherine Cohn, counsel at the Washington. Let's see, my screen is frozen. I'm sorry. I'll just say the names. Catherine Cohn, Dean Hunter, Nathaniel Aquino, Brianna Campbell, Wan Young So, and Daniel Batts. Mr. Batts is going to be called in, so he may not appear right away.
All right, thank you very much. And we will hear from Ms. Conan as soon as she is available.
Good afternoon. My name is Kat,
How are you doing?
and I am a fair housing staff attorney at the Washington Lawyers Committee for Civil Rights and Urban Affairs. Thank you for the opportunity to testify. The committee is here to express our strong support for the Fair Tenant Screening Act and the Eviction Record Sealing Authority Amendment Act. Because both bills raise important civil rights issues, we ask the council to pass these bills to advance its commitment to racial equity and to further fair housing in the district. We offer 2 recommendations to strengthen the Fair Tenant Screening Act. First, ensure that the bill modifies the DC Human Rights Act as written, rather than the Rental Housing Act, to provide tenants broader remedies, including a private right of action. Second, limit even further the information landlords can use to screen applicants in Section 227, as well as require background screening companies in Section 229 to certify their reports are accurate. The Fair Tenant Screening Act will provide critical protections to low-income DC residents who are routinely denied housing due to unfair rental housing practices that are often aimed at excluding low-income tenants or tenants with subsidies. Many of these practices, such as prohibitions on renting to tenants with low credit scores or certain eviction histories, have disproportionate and discriminatory effects on DC tenants of color who constitute the majority of tenants with low incomes. Critically, the Fair Tenant Screening Act will help break down many of these barriers for prospective tenants with subsidies by prohibiting landlords from asking about or considering these tenants' history of unpaid rent that happened prior to receipt of a subsidy, their income levels, their credit scores, and credit problems that occurred prior to the receipt of the subsidy. The Eviction Record Sealing Act will also remove housing barriers by requiring the sealing of certain eviction records, a practice that will favor DC tenants of color who are more likely to be evicted compared to their white counterparts and more likely to have eviction records appear in their background screening reports where they could foreclose future access to housing. A fall 2020 report by Georgetown University noted that citywide, almost 11 out of every 100 renter households in DC received an eviction filing in 2018. But in Ward 7 and 8, communities with larger percentages of Black residents, 20 out of 100 and 25 out of 100 experienced eviction respectively. In Ward 2, which has among the smallest share of Black residents in DC, fewer than 3 out of every 100 renter households received an eviction filing in 2018. The Eviction Record Sealing Act is therefore a critical step to addressing the harmful impact of eviction records, particularly on tenants of color. With respect to the Fair Tenant Screening Act, we firmly believe that the procedures and remedies available under the Human Rights Act are necessary to fully redress violations of the Act. First, the Fair Tenant Screening Act raises significant fairness and civil rights issues, and for that reason alone, it should be located within the DC Human Rights Act. Second, if you locate the Fair Tenant Screening Act in the Rental Housing Act, you will shortchange DC residents by prohibiting them from accessing a more meaningful set of remedies, including the option to file a charge for a violation of the Fair Tenant Screening Act with OHR or to file a complaint in court. Further, because tenants whom the Fair Tenant Screening Act intends to protect are low income or rely on a subsidy to afford their rent, they are members of the very same vulnerable population that the Human Rights Act intends to protect. Relatedly, the Washington Lawyers Committee believes that OHR is better suited than DHCD to identify and investigate discrimination as the agency responsible for investigating discriminatory housing practices, including on the basis of source of income. The Fair Tenant Screening Act provides protections for subsidy holders, among other protections. That said, we know OHR has suffered prior delays and issues, so to ensure the agency is able to successfully address violations of the Fair Tenant Screening Act, we suggest that the council commit to expanding OHR's budget. Finally, the Washington Lawyers Committee proposes that the council amend sections 227 and 229 of the Fair Tenant Screening Act. In section 227, we recommend including a rebuttable presumption along the lines that Mr. McDaniel testified to, that a housing provider is presumed to have denied a prospective tenant housing on a basis prohibited from consideration, including a prior or pending eviction, if the prospective tenant establishes that the housing provider requested or received information through a background screening report that was based on court records relating to a potential tenant. Ensuring that eviction history does not serve as a reason to deny housing is a matter of fairness, particularly with respect to a pending eviction, which does not provide any meaningful indication of whether a tenant is able to meet the obligations of tenancy. This is especially true for so many DC residents who have been hard hit by the pandemic and have lost work and income necessary to pay the rent, making them fall behind on rent. We also recommend that the council ensure housing providers are precluded from denying prospective tenants housing based solely on scores, recommendations, or background screeners' conclusions. These alleged indicators of fitness for tenancy often adversely and disproportionately foreclose housing for tenants of color, and often provide no meaningful indication of whether a tenant is able to meet the obligations of tenancy. Finally, the council should revise section 229 of the bill to require background screening companies to certify to the district that their background screening reports are accurate. Thank you, and I will submit a copy of my written testimony.
Thank you very much. Our next witness, Dean Hunter.
Good afternoon, Councilmember Bonds.
Good afternoon.
Thank you for the opportunity to discuss these measures today. I'm truly pleased to not have to use my time to beg you to pass an amendment to give us access to the courts today. So we thank you for that. But let me be very clear. We are here to testify in strong opposition to these measures as they are currently written. Both of these measures are excessive, unnecessary, overly broad, and overly burdensome, particularly upon small housing providers. Most of the provisions of these bills are covered already in federal law. The provisions that are not covered in federal law we present are a legislative aberration. One of the things that we have consistently advocated is for the council to legislate housing providers in a different manner than they've done before. One size does not fit all. We have made it very clear that half of the rental housing in the District of Columbia is provided by small landlords, people that rent out their homes, condos, and then half of the apartment buildings are 20 units or less. These are small housing providers. This legislation came about as a result of a story, news media reports about large corporate providers abusing the system, not small landlords. We cannot and we should not implement a one-size-fits-all policy that frankly will have an adverse impact on the provision of naturally occurring affordable housing. You know, you talk about shifting burdens and tests. There used to be a time where the government legislated by a thing called best practices. And best practices were determined by what was being done in other states. I submit we should have the same test. If it's not being, what's being done in Virginia? What's being done in Maryland? What's being done in the majority of states? And if it's not being done anywhere in America, there's a good reason for that. It should not be done in the District of Columbia. This bill must be amended. And we're going to put the amendments in writing. Number one, the requirement of a basic business license for an eviction is a trap. You know that people live together in housing now. You have group homes and things of that situation where they're roommates. They don't have a basic business license. But what you're saying, you can't evict under that circumstance. You have individuals, basic business licenses requiring an inspection. The tenant controls the premises. So right now we have a problem where landlords can't get basic business licensing because they can't get access to the facility. This is an unnecessary burden, needs to be eliminated. The criminal penalties, the civil penalties, where else is that done in America? Why is that necessary? We already have what's called the Consumer Protection Act, which protects every consumer uniformly. It provides a private right of action. We don't need to codify additional penalties for small landlords who make one mistake. This is not good legislative policy. Will have a very adverse impact on the provision of affordable housing. We intend to work with the DC Realtors and AOBA to really try to get rid of the most harmful provisions of this bill. Thank you for your time. We will follow up with staff and submit something in writing.
Thank you very much. Our next witness, who is our next witness?
Witness is Nathaniel Aquino.
Okay, Mr. Aquino.
Good afternoon, Chairperson Bonds. Thank you for the opportunity to testify today. My name is Nathaniel Aquino, and I'm a senior staff attorney with Legal Counsel for the Elderly in the Tenant Advocacy and Support Practice. This team combines social work, legal, and volunteer services to ensure that the district's elder population can age in place by preventing evictions and protecting access and the right to safe and habitable housing. I'm testifying today in support of both the Fair Tenant Screening Act and the Eviction Record Sealing Authority Amendment Act. These two bills represent an important opportunity for council to enact permanent protections for district tenants, helping to re-level the playing field with landlords. It is especially important to recognize that communities of color, those without financial safety net, the elderly, and the disabled bore the brunt of the crippling COVID-19 pandemic. And now, as the district emerges from the last 14 months of isolation, it is as important as ever that the council recognize the need to bring equity to those who have been impacted the most. To that end, my colleagues and I first wish to commend this council for its efforts and its consideration of the Fair Tenant Screening Act of 2021. This act will make permanent numerous important and necessary tenant protections. Due to time constraints, I will only be able to highlight a few examples in the short time allotted, but Legal Counsel for the Elderly's written testimony goes into much greater detail as to the ways in which the district's elder population will be directly impacted. And my plan is to submit that written testimony after this hearing. The Fair Tenant Screening Act will create much needed transparency in the tenant screening process. Senior tenants tend to be less transitory and spend years at a single address. So when the time comes that they need to look for new housing, they often lack essential information when applying. I've spoken to far too many elder tenants throughout the district over the years that are distraught after literally spending their grocery money just paying application fees for apartments that they eventually find out they would have never qualified for. Private screening companies wield unchecked power in deciding whether or not a prospective tenant gets a yes or a no, requiring housing providers to state specific reasons for denial, how an application fee was spent, what records were used in the decision, how to appeal, empowers tenants to determine whether the denial was fair and lawful, or often just as importantly, whether the applicant wants to apply for that unit at all. Additionally, the Fair Tenant Screening Act provides protections to district housing voucher holders, 31% of which are 62 years or older. While voucher holders should already be protected from discrimination, the Fair Tenant Screening Act would finally close a loophole that allows landlords to deny admission based on arbitrary income and minimum credit scores. Minimum income and credit score requirements should not be required for voucher participants, since voucher holders are only responsible for paying approximately 30% of their income as rent. For an example, take a voucher holder seeking a 2-bedroom apartment with a monthly income of $1,000. If she finds an apartment listed at $1,500, she will only be responsible for paying approximately $300 of rent, while the voucher covers the rest. In that circumstance, a required minimum income is nothing but a wolf in sheep's clothing. It makes little to no sense to require a minimum income reflective of the full rent when the payment by the housing authority is guaranteed. Finally, I would like to reiterate Legal Counsel for the Elderly support for the Eviction Record Sealing Authority Amendment Act. For many tenants, especially seniors with fixed incomes, an eviction or even just having an eviction filed against them can have devastating consequences on their ability to find housing and therefore on their health and well-being. And while prospective landlords rely on court records as a screening tool, court records do not tell the full story. I'd like to tell one quick story, and that is of a former legal counsel for the elderly client, a 65-year-old veteran. He was sued as an unauthorized occupant of a home that he had lived in for years after his landlord sold his home to a new purchaser. Eventually, the court dismissed that case, but only after he was required to appear at court and show evidence of his longstanding tenancy. Although this case ended in the tenant's favor without record sealing, that filing remains on his record and presents a barrier to finding affordable housing in the future. Competition for the district's diminishing affordable housing stock has long been intense. And with the loss of income seen across low and middle class residents, it is only going to be increased. Housing scarcity helps to explain, but does not justify a landlord's common practice of rejecting an applicant with an eviction on their record, regardless of outcome, circumstance, or legality of the filing in the first place. As a result, this leads to tenants having an immense fear of being forever marked by landlords as untouchable. Sadly, this compels poor tenants to avoid court involvement at all costs, choosing to endure terrible living conditions or comply with unlawful lease terminations rather than defending themselves in court. And so meaningful eviction record sealing will go great lengths to allaying those fears, and we encourage council to pass this important legislation. Thank you for the time today, and if you have any questions or concerns, I'd welcome the opportunity to discuss those further. Thank you.
Thank you very much for your testimony. Our next witness, I believe it's Ms. Campbell.
Yes, but she's not on right now, so we could move on to Mr. So.
Okay, Mr. So then, all right.
Good afternoon, members of the Committee on Housing and Executive Administration. So my name is Won Young-so, and I'm a PhD student at the Department of Urban Studies and Planning at MIT. So I'm here because I fully support the B24-96 Bill Eviction Record Sealing Authority Amendment Act of 2012. This is because my research shows that landlords tend to maintain blanket policies of rejecting any tenant with an eviction record, even when they have access to information that the eviction was dismissed or settled. So I conducted a behavioral experiment with 209 landlords. 60% of them were small landlords, to test how they interpret eviction record on different types of tenant screening reports. So I measured landlord decisions. They could accept, reject, or conditionally accept tenant with a security deposit. So what I found in the study was the following. So first, on average, landlord interpreted the presence of any kind of eviction record as risk, even dismissed or settled, and impose penalties on these applicants or do not rent to them. So this means that even when landlord had enough details to assess an eviction appearing in the report was dismissed or settled, they did not use that information to assess the applicant more positively. So this indicates that more detailed information in the report do not translate into different or more equitable decisions for tenant. And second, landlord were swayed more by the tenant screening report interpretation of the applicant's record, represented as a high, medium, or low risk score in the experiment. So I found that these risk scores had a bigger effect on landlord decisions to accept or reject an applicant than the details of the eviction record. So this is actually a well understood pattern called automation bias. So when humans place too much faith in automated systems. So in the last part of the experiment, I asked the landlord about their decisions in the experiment. Many landlords noted that they consider eviction to be higher risk than criminal record. However, they did not distinguish between different types of evictions or consider eviction details. So I bring one landlord response here, quote unquote, I basically wouldn't rent to anyone with an eviction. It doesn't matter how long ago or how the case was disposed. So for them, both eviction filings and eviction judgment were just evictions. So to summarize, on average, landlords perceive any eviction record as a risk and make inequitable decisions. For this simple reason, I support B24-96, which would seal eviction record. And thank you. I will send the research draft to you for any council member want to see the details, and then I'll send you the written testimony as well. Thank you.
Thank you very much for your testimony. And yes, please send your information forward. I would be very interested in seeing it. Thank you very much for that testimony. And I think our next witness is the witness that would testify on the phone, Ms. Bates.
Yes, it's Daniel Batts. I'm going to try to unmute him. But Mr. Batts, if you can hear this, if you press *6, that'll unmute you and you can begin your testimony. Mr. Batts, it looks like you're unmuted, so whenever you want to begin, go right ahead.
Hello?
Hello, we're waiting to hear what you want to tell us.
Oh, okay. My name is Dan Batts. I'm 73 years old. I'm a Vietnam veteran. I moved from Norfolk, Virginia to Washington, D.C. in 1974. I worked for the Department of Recreation for 8 to 10 years. I worked for Marion Barry's Summer Jobs Program, Time Life Books, a political fundraiser, a telemarketing supervisor, marched with Stevie Wonder for MLK birthday, marched with Angela Davis, Ben Chavers, Julian Bond, Walter Fountain, and Million Man March. And I've been in D.C. since 74, and I'm a registered voter, political activist. I moved to 5601 13th Street in 2008 to the present. And in 2014, the ceiling collapsed in my living room. In 2017, the ceiling collapsed in my bathroom. And my personal property was taken from my property from 2008 to 2017 under the management of S&R Management. Now, the ceiling stopped in 2018 under the new management of Thomas Walsh. Checked with the 4th District Police Department as a matter of record. Other people's property was taken from this building, being bought by Petra Recreation, realtors. And in 2014, I reported that it was housing that she was not. I reported to a supervisor from housing about my property being taken out of my apartment. She told me not to worry about other people, worry about myself. And for a period of 2008 to 2017, my personal property was taken from my apartment. It's all in the 4th District. I'm 5601. Just about my attempt to move, I went to a place called Quebec House in Cleveland Park to rent an apartment. I was turned down based on my income and race, I believe. Then I went to another apartment to move out of this building called UIP. I paid them $40 application fee, $150 to hold the apartment. They never responded to that. I reported it to the housing authority, and nothing ever came with that. I'm still stuck here. They're selling the building. They're supposed to be offering each tenant $30,000 to move out. And this has been a mess since I've been here. A lot of my property was taken, records, clothing, bonsai tree, a number of other properties were taken from my house by the people that work here, maintenance people and things like that. That all is reported as a matter of record of the 4th District Police Department. And so I just want you to know that I've been here a long time, and I've been an activist for quite a while. I'm an old man now, and I've suffered a lot of problems since this housing thing came up. I haven't been treated fairly.
Thank you, Mr. Bat. We want to work with you. So we have, I'm pretty sure we have your phone number. If not, would you make sure that we get your phone number so that we can be in touch with you a little later today?
Okay, yes, it's 683-5435, area code 202.
Oh, all right. Well, thank you very much, sir,
We
for that.
need
But
help.
we are going to work with you and see if we can't get a couple of these issues straight for you.
Yeah.
Most definitely. But thank you very much for testifying today.
All right, thank you.
Mm-hmm.
Is that it?
That's, unless you have some other comments you want to put on the record, I think we're real clear that, as you said, you have had a number of problems. The one that concerns me right at this moment is the fact that you have been denied an opportunity to move and been encouraged, yet you've been encouraged to move. And to sweeten the deal, you've been offered $30,000 to move. So we really want to find out what's going on in this particular situation at 5601 13th Street.
13th Street. It's a matter of record. A lot of people property was stolen over the years, and and the maintenance people were the ones that was doing it. They still work here, but they've stopped stealing from me.
Okay. All right. Well, we want to work with you, and I thank you very much again for your testimony. And thank you to all of our witnesses today. I do have a question, since we are talking about a couple of specific bills. I wanted to ask the panel if they have recommendations on what information should be or is needed in order for a housing provider to make a decision as to whether or not a tenant is suitable for their building. And I'll start with you, Ms. Conan. I see you.
Yes, thank you, council member. Well, I think that there are plenty of other indicators landlords can use. For example, they obviously will receive a copy of a full application. Sometimes they request the names of prior housing providers, like prior buildings where the tenant resided previously. So they can always inquire as far as the ability to pay and the consistency of rental payments, whether that tenant actually did complete their payments with respect to, their prior housing history. They obviously also require income. I'm sorry, that's my dog in the background. They require proof of income, which is also very helpful. I think that with respect to subsidy holders, however, the minimum income requirements are really inapplicable and irrelevant because generally the subsidy will either cover all of the rent or a significant portion of the rent. I also think that with respect to consumer reports, we're not asking that landlords not receive these reports. We're simply asking that they not consider some of the information in those reports that tends to have a discriminatory effect on tenants of color.
May I ask then, what are your thoughts about credit rating?
I think credit ratings are very problematic. I know one of my colleagues testified to it earlier, but essentially for a lot of low-income tenants, they haven't had the opportunity to build credit. And so oftentimes there is a negative inference taken from the lack of credit. I also believe that with respect to, again, subsidy holders, credit is irrelevant. And it's also not a good indicator of whether that tenant previously paid rent. So I'll pause there and turn it over to some of my other colleagues who I think have similar suggestions.
All right. Mr. Hunter, do you have some thoughts on the information that should not be a part of the application or the process that you review before you decide on a tenant?
Councilmember, we believe that DC landlords should have the same access to information available to Virginia landlords and Maryland landlords. I think one of the things we should have learned from the eviction filing moratorium is that we shouldn't just make this stuff up as we go along. There's not some best practices is what we should utilize. We are not the District of Tacoma Park and just pulling up these experimental measures just because we think they're good ideas. We should look at, because it causes harm when we do that. And we see the harm that this eviction moratorium has caused. We should look at what's being done. I'm not an expert in all that what should be required on a rental application, but I know what should not be there: criminal penalties, referral to the Office of Human Rights, measures that are not in the law in other states. We're tying the hands of our housing providers behind their back, and we're getting people out of the market with these draconian measures. If it ain't in Virginia, if it ain't in Maryland, it shouldn't be in DC.
Thank you, Mr. Hunter. And I can understand that sentiment from you, given that your association members probably work in all three jurisdictions. So I understand that. Thank you very much for that comment. I wonder, Mr. Aquino, do you have anything you would like to add as it relates to information that should not be included in the file or the application that a tenant puts forth for occupancy at a building?
I think I echo what Ms. Cohn, unsurprisingly, echo what Ms. Cohn had to share. I think one thing I do want to say is it's okay for the district to be a leader in bringing equity back to people who have been marginalized in the district for so many years. I don't think the only standard that the district should be looking at is best practices. It's okay for the district to be a leader and to be on the cutting edge on equitable remedies to issues in the housing market. I want to also add to the credit rating issue is, especially seniors, I've noticed in working at Legal Counsel for the Elderly over the past almost 6 years now, tend to be long-term tenants, and they tend to not have expansive or a lot of credit. If someone who is a lower income person, they're not going out, they're not taking out a mortgage. Obviously they're tenants. They are not going out and doing all of these things that the credit reporting agencies might really look at in a more favorable way. And I think to use that as a benchmark that must be met in order to bring people into a unit is really problematic. And finally, again, Ms. Cohn raised this too, and that's one of the really difficult things for tenants with vouchers, specifically in the district, is they are judged by the same standard as if they are not bringing basically a blank check with them, which is what a voucher is. The housing authority is going to pay that rent for them, and it's oftentimes almost all of it. So to require a credit rating of whatever number and to require a certain amount of minimum rent, there's no direct correlation to whether or not that person is going to be a good tenant. So, I think financial information, I think my colleague from Bread for the City spoke about it in the first panel. Financial information is important, and I don't think anybody here is necessarily saying that information cannot be asked on an application. I think the question there is what information is being reported to the landlord by the credit reporting agency, and whether or not that's directly relevant to whether or not that makes them a successful tenant.
Thank you. Thank you very much. And Mr. Sewell, I will not pose that same question to you. We are very curious about your research, however. So thank you very much. And thank you very much to this entire panel. Thank you. our next panel, I believe, is Mr. Bianco, Rich Bianco, I believe.
Yes, I can call, oh, Mr. Hunter is saying that he's not testifying.
Correct, correct.
Okay, thank you. So we will not call Mr. Bianco. The next panel will consist of Carissa Span, Chris Alston, Evan Lukadakis, and someone who is not given their full name and wants to go by DB.
All right, we're ready.
And Gabrielle, I do not believe Ms. Span is here either. So as you see, Councilmember, you can see Mr. McCabe. I think he is the first one here on this panel.
Yes, Mr. McCabe, we'll start with you. Thank you very much.
Great, thanks very much. So I'm Brian McCabe. I'm submitting this testimony on behalf of myself and my colleague Eva Rosen. We're faculty members at Georgetown University in the McCourt School of Public Policy and the Sociology Department. And as many of you know, we recently completed a comprehensive report on evictions in the district that draws on 5 years of court records about the eviction process. The report has been widely cited by policymakers, advocates, and the legal community as discussions have unfolded over the last year about eviction in the city. So I'm here today to underscore the importance of record sealing to protect tenants from unnecessary harm and housing instability, but also to make a plea as a researcher to ensure the availability of these records for researchers so that we in turn can help to inform and to improve public policy. So today I'd like to make 3 points. First, record sealing does help to ensure housing stability for renters. Currently, as you know, all records in Washington, D.C. are publicly searchable from the Superior Court website. This searchable public information includes the full names and addresses of every tenant with an eviction filing, regardless of the outcome of the case. So this includes all of the filings that were quickly dismissed when back rent is paid, which, as our report shows, makes up the overwhelming number of cases. Landlords can and they do access these records, often with the help of third-party data aggregation companies, to discriminate against tenants who are looking for housing. And simply having a filing, even a filing that's quickly dismissed when the rent is paid, is harmful for tenants. So I won't belabor the point, it's been made by many other speakers, but I just want to sort of emphasize the difference between an eviction filing and an executed eviction, and note that those are both used by landlords when they screen tenants. So second, I want to implore you to recognize that the records must be sealed immediately upon filing. So in order for record sealing to be effective, it needs to occur at the moment of the filing and not later in the process. And this is for one simple reason, right? We live in an era of big data with a number of third-party data aggregating companies regularly scraping court records, compiling them, and selling the data. Property owners buy this information and they use it to make decisions about whether or not to rent to prospective tenants. So any legislation that allows for the records to stay public through the eviction proceeding or for a period of time after the resolution of the case provides an opportunity for these companies to scrape data and to use the information against tenants. Again, any period of public availability, 1 week, 2 weeks, give these companies a window to scrape the data. It's exceedingly difficult to get these companies to update their records upon completion of a court case or to remove filings that do not end in an eviction. So if you allow any sort of public availability of these records, then you've defeated the purpose of the legislation. The records must be sealed or masked the moment that they're filed. And then the third thing is I want to encourage you to carve out specific exemptions in the legislation to enable researchers to access the data to serve public policy. And again, I'll point to our report. Yesterday, I read a tweet by Councilmember George about the geography of eviction. Councilmember Bonds, you cited data from our report in your opening remarks. Others on this call have cited our report. This data comes from, this information comes directly from the report. It's been cited by the council, advocates, legal community. The report and the policy that I think it's helped to inform was only possible because we as researchers had access to that data. So since the emergency legislation was passed with record sealing included, we no longer have access to the eviction records as researchers. This is critical to note because without access to the records, we're not able to provide up-to-date analysis once the moratorium is lifted about eviction filings in the city, and this will negatively impact the ability of the council to make data-driven policy. So I want to emphasize that we need to preserve access to all eviction records by researchers to properly understand and analyze ongoing eviction trends in the city. Where other cities have passed record ceiling bills without delineating a clear pathway for researchers, tracking evictions has become very, very difficult. It hurts tenants and it creates challenges for public policy. Finally, I'll just say I'm pleased to report that the Superior Court system has an excellent system of creating data use agreements with researchers that provide access to court records. It's a system, in fact, that I think should be widely emulated by other agencies in the city that are looking to provide access to data for researchers. The council must ensure that researchers who comply with the requirements of the court system are able to access this full database. And as we continue to have conversations about data availability throughout the city, I hope that the court system will serve as a model for other city agencies. So with that, I want to thank you for the opportunity to testify today. We're appreciative of your continued leadership on this issue and grateful for the seriousness with which the council has considered and engaged with our recent report in shaping legislation in the city. Thank you.
Thank you very, very much for your testimony today. Will we get written testimony from you? Is that correct? All right.
Yes, Councilmember,
Thank you so much.
I've submitted it.
Thank you. I think our next witness is Mr. Alston, Curtis Alston.
Yes, ma'am.
All right. Okay. How are you?
I'm great. How are you doing today?
All righty.
All right. Thank you for having me today. So I'm here to support the Fair Tenant Act and the Eviction Record Sealing Act as well. So my name is Curtis Austin, and I'm a permanent supportive housing case manager at Metropolitan Education Solutions. I'm here today to speak on the behalf of the population I serve and represent. As a case manager, I have witnessed firsthand the discrimination and marginalization of those I represent. Sadly, when some of those individuals were asked would they be willing to testify, they opt out based off a belief that nothing would change. The clients I service are individuals who might not have the same background, resources, or financial status as others, but that does not make them second-class citizens of the District of Columbia. I have clients that have raised their credit scores in hopes of better units in areas, maintain employment, been compliant with lease agreements, only to be treated less than because of having a voucher. I also have those that have rental blemishes in the past, but have since corrected them. Those past indiscretions were used against them with no explanation or opportunity to defend themselves. Some clients have been denied based off credit score alone, and even more that have paid application fees with no unit or refund. Then there's been some that have been told that their income must match a certain amount, but why when a subsidy is being paid? All these are just ways to say, I don't want to rent to you because you have a voucher without saying it. This must change. It's a quote that says, "From the equality of rights springs identity of our highest interest. You cannot subvert your neighbor's rights without striking a dangerous blow at your own." Council members, we have an obligation to love our neighbors as ourselves. The people I serve are our neighbors. Not to pass the act would be an injustice to our own rights. These acts will help ensure fairness is exercised and that past actions will start to become a thing of the past. I believe that the Fair Tenant Act will help accomplish this. I also believe that Eviction Record Sealing Act will help clients that have been rejected based off something in the past when their present life does not hold the same blemish. Everyone deserves an opportunity, but when you're judged by the standards that have created these barriers, that's not an opportunity, that's a closed door. I support the Fair Tenant Act and Eviction Record Sealing Act, that equality may be extended to those who have not received it. And I want to thank you for letting me be able to testify today.
Thank you very much for your testimony today, Mr. Austin. And I'm not sure I know our next. Do we have another witness?
Yes, council member. The next witness is Evan Lukadakis.
Okay, Mr. Lukadakis. Okay.
Okay. Good afternoon, Chairperson Bonds.
Okay.
Sorry. Housing and Executive Committee, staff members, thank you all for allowing me the opportunity to speak. My name is Evan Lukadakis. I'm a Ward 6 resident representing the DC Association of Realtors, DCAR. Our 3,000 members are a voice for real estate professionals, small housing providers, and most importantly, homeowners and renters who live and work in the district. I'm here to raise several concerns DCAR has for Bills 24-106 and 24-96 that we believe would cause heavy adverse effects on small housing providers. Our members understand the author's intention behind these bills is to protect tenants. Our members work with tenants day to day, and we want to maintain reasonable safeguards. However, a clear point must be made that these proposals, specifically in Bill 24-106, the Tenant Screening Act, make daily operations for small housing providers unduly difficult. What this bill attempts to address is actually already covered by the Federal Fair Credit Reporting Act. For example, the act requires a housing provider to give written notice to a prospective tenant if their application was rejected, which must include the reason why the application was rejected, the applicant's rights and ability to challenge inaccurate information, the name of the reporting agency that was used, and the applicant's right to receive a free copy from the agency. Another concern is that the way this legislation is written can expose housing providers to violating the Fair Housing Act with the 72-hour dispute process, which is legally highly problematic. The Fair Housing Act requires a housing provider to rent to the first qualified applicant, which this bill also proposes, but the language suggests that if a prospective tenant can demonstrate mitigating circumstances, then the housing provider must rent the available unit to them, effectively precluding other qualified tenants from the unit. This isn't the only provision that would open housing providers to liability. According to the bill, a housing provider must waive any application fee and consider a prospective tenant's own background report, which may not meet fair housing standards. And if the housing provider wanted to obtain supplemental background information, then that would come at their own expense. There are several other points in this legislation that DCAR is strongly concerned with. However, we are certainly committed to working with the committee and authors to allay these concerns. We do hope in the future that the district initiates policies that encourage more small housing providers to enter the local housing market. Unfortunately, the current legislative conditions are fostering an environment where only financially fit, resourceful, large operators can survive. As always, thank you, Chair Bonds and Housing Committee members for the opportunity to provide testimony. We look forward to working with you all to ensure that tenants and small housing providers are well represented in the legislative process. And I'd be happy to submit my testimony in an email.
Thank you very much. And please do submit your testimony, your written testimony. Thank you again. I think we have one other person on this panel.
Yes, Councilmember. It's someone on the phone, DB. I see you're unmuted, so you can go right ahead whenever you're ready.
All right.
Yes, DB is here.
All right,
Good
please
afternoon.
go ahead.
Thank you. Good afternoon. My initials are DB. Let me just do some housekeeping. First of all, I am a native Washingtonian. I have a doctor's degree. I've held top secret security clearance in the District of Columbia. I don't have any debt, never been incarcerated. I've been on DCHA's waiting list for over 30 years. I had a hiccup. I actually gave my spot up to someone who needed it earlier on, and they put me back on the list. So I was on there a little long. Got a hiccup, received a federal voucher and went forth to look for housing. First and foremost, the DC City Council, if it was not for Brianna Newdell's office, I would have gotten no help, received no help. I went directly to Anita Barnes' office. I walked in personally. I first sent the email asking for assistance. I had one question only for DCHA. And that question was, how much do we pay? Not only did the office did not help me, but it was a hindrance. The director, Tamika, I cannot remember her name now, was explaining to me how long she's been on the voucher program and she wished she had a voucher. I'll talk to DCHA, and it was a total fiasco. Finally, we heard nothing back from Anita Barnes' office. We heard nothing back from DCHA. I went down to the office to meet with Attorney Persky, which I spoke with on the phone. Miss Fennell met me and my daughter, and she said he was busy. He already informed me that he was busy and that he would speak with us. She took no notes. When he came in, he asked for us to sign a release document, which he had her to send. Now, while we were meeting with them, her statement was, oh, you may need to file an appeal. We asked her why. It comes later to find out that she had got a hold of my documents without me signing over anything. Secondly, it took me 1 year to get an answer from DCHA as to how much do we pay. I had to go through Eleanor Holmes Norton's office to get to the federal government just so they could tell me how much we pay. A answer DCHA should have already told me under your care. I asked that one question. The executive board of DCHA came back to me as though I have committed a sin. Also, in regards to the voucher, a few panelists have spoken out about the voucher. The moment you present the voucher to anyone, oh God, no. Again, I have already stated to you, I don't have any debt. I don't have any bad credit. But the moment the word voucher comes out of my mouth, oh no, we need to see your credit. We need to see all. This is ludicrous. Absolutely ludicrous. This entire office needs to be restructured, because I believe if you were out here with the people, I don't mean like a month, I mean 4 years in a shelter, so you can understand how the shelter patrons have been, treated as though they're scum of the earth, third-class citizens. Why is that? Again, I have a doctor's degree, and these are things that I see. What is this? So this whole process with the office and the homeless needs to be restructured. There is no sympathy, there is no empathy, and there is no understanding. DCHA's executive board needs to be restructured. We are on a timeline out here with a voucher. So we don't have time to go through the rigmaroles of people stalling in-house. I have a landlord. We're already in the house, thank God. If it was not for me, Brianna Nudo's office, and the landlord working together, we would not be here. The information on DCHA website is faulty. So when a landlord pulls it down and tries to submit it, oh no, this paperwork is incorrect. But this is on their site. This also creates a stumbling block for those voucher holders who are trying to receive housing. It's on the website should not be in error. It causes a complete backlog. There is almost no communication from DCHA. And a last little tidbit that I must add, DCHA had a program during the pandemic for housing recipients or on the waiting list or whatever to receive gifts for Christmas. There was nothing given out. There were two lines wrapped around the block, standing and in cars. There was nothing to indicate any wrongdoing. The people were outside for a long time. They just closed the line. My question, what happened to the gift? What happened to the money? Where did it go? Did the people in-house get it? Because none of the people that were standing outside received anything. My experience with the housing program, with Anita Barnes' office, with DCHA is below human, substandard, and it needs correction. Maybe we need fresh blood, but this cannot go on. If I myself was frustrated, and I have people out here, again, who do not want to come forth and testify because they don't think anything is going to be done, especially, after I told them that, there's somebody inside the council office says, oh, well, I've been on, I've been on the waiting list. I ain't gotten anything. I want to, what is that? You're supposed to be here to help and serve. That's all I have to say.
Thank you very much for that testimony. And there you brought up a number of issues. Sorry that you felt the service that you got from my office was below standard, to say the least, and I apologize for that. And Miss Tamika she is not with us any longer, but I'm sure that we will convey to her that you felt very lacking in your encounter with her, and I really do apologize for that. Just so you know, the Housing Authority manages the voucher program, and you mentioned that you had come through the shelter process. Am I correct that you were, if you were in
Well, yes, I do understand that the housing DCHA manages. We were homeless. Now, I had applied for a voucher before, 30 years ago.
Okay.
You know, yes. Yeah.
Well,
So that was.
Let me just say, Miss B, just so you know, the vouchers that the government currently disperses, almost all of the vouchers, at least if they are through and 2 persons through the shelter program, are really determined by the Department of Human Services for the most part, if you are in the shelter.
No, but I understand that, but I did not have a DHS voucher.
Okay, well, all right. So you had a different kind of voucher?
I had a federal voucher.
Okay, if you had a federal voucher, that voucher again it is also handled through the DC Housing Authority, and they follow the federal rules. What I really think we have to do is to look at why you were denied, because there is a law against that. And so that's one issue in particular, along with the issue that you raised about the service or the lack of service from my office. And I just wanted to make sure that I get all of this information, because it's very, very important, as you have pointed out, that once we receive this negative information, that we can act on it and that we can improve the system. But I wanted you to know that my office does not have any jurisdiction over the shelter process. You were at the right place by going to Councilmember Nadeau for that, because that is the Department of Human Services. So I just wanted to clarify that in the event you thought that all housing is under our office. So I just wanted to clarify that.
Thank you for clarification, but no, I'm well aware that Nadeau's office is over DHS and your office is over DCHA. You know, yes. My concern was, since your office is over DCHA, you know, and DCHA is the managing office for district vouchers, and they also govern DCHA issuing the vouchers, but also they manage federal vouchers. My,
yes,
when
you know, Ms. B, what that means is when you say they manage it, if you have a federal voucher, it really means that the location where you live is responsible for making sure that the payments get to the landlord. But
right, that was not the problem. That was not the issue. The issue was the communication. That's the biggest issue. I'm well aware of, you know, where the money goes and this, that, and the other. I'm well versed in that. My issue was the communication process, because when I was trying to secure housing earlier, prior to now, again, you know, we're happily where we are, my family, myself, but, you know, it was tremendously difficult to get a response from DCHA. And understand this lack of response, it's like the sand of time eating away at the voucher. When we're trying to get a resolution here, they make it extremely difficult for the voucher holders. They make it extremely difficult for the landlord. This is like this lack of communication. And then when I ask one question, this is a very simplistic question. What do I pay? I have the executive board come to the office. We're assured. Just answer the question. I had to go through Eleanor Holmes Norton's office to get to the federal government just to send me an answer to a question that DCHA should have already answered. What is her VP? What is it? Ponder? My God, that's ridiculous. We're taking your voucher. What? Because I asked you a question? You mean to tell me nobody can tell me a simple question without threatening and harassing me? You wouldn't believe the amount of people that I've talked to that they just giving the vouchers up. They're giving them up because they make it so difficult. They make the barrier so tight. Oh no, you didn't do this. You didn't sign this paperwork. This one lady was in the shelter with me, DHS shelter. She had a DCHA issued voucher. Her husband passed away. They snatched her voucher. What? The whole family is on the voucher. Why would you snatch it because he passed away?
Miss B, I hate to interrupt, but could you please just, when you scream, your voice
I apologize.
Okay.
I do apologize. I do. I really do.
I'm trying very hard to hear what you have to say, to think of what we can do to help straighten it out, but I can't if you're going to continue to scream. I really can't.
Yeah, I apologize for that. I do. That just lets you know the amount of frustration. But I will do I will do my best. I do apologize.
Okay. Yeah. Well, if you want to talk further with us in my office about the housing authority and the communication issue, please give us a call. Okay. Or you can, if you would leave your phone number, you don't have to do it over the air now, but if you would get us your phone number, we would be very happy to hear you through on any of the issues and then work to get those cleared up immediately.
Okay.
All right. I appreciate it very, very much. And thank you. And sorry again that you had difficulty with my office. My apologies.
Okay.
And so I wanted to ask, as it relates to, of the panel, as it relates to the applications that individuals put forth, is there a sense that there should be, I'm coming at it from a different angle, information that is not necessary in an application for a rental unit that can be omitted? Mr. Austin, I'll ask you because I know you spoke a little bit to this.
So when it comes to the application and when they are applying, if you already know that it is a voucher holder, then as far as income, sometimes it shouldn't play a factor, because even if you have a voucher and you have a portion that you pay, the government pays a majority of it, and the client only is going to pay 30% of whatever their income is. So it really has nothing to do with the bulk of what the rental payment will be. The other thing is also too, when it comes to asking about, credit score, that's another thing that doesn't have to, because I have clients that are zero income, and being zero income actually means that the government pays the whole rent. So why should that even be something that is considered at that point? Because your credit, when you go for anything else, is based off your ability to handle the bill that you're trying to take on. With the if it's being covered by the government, then why should you even have that in the application and ask, or that be something that you run or even speak about?
So then I have to ask, if a applicant for housing is a voucher holder or recipient, should the value of the voucher be included in any questions about their income as it relates to their ability to pay?
So when it comes to a, so let's just say, let me give you an example. So let's just say the voucher is a 2-bedroom voucher. That 2-bedroom voucher has a certain number attached to it for utilities and without utilities. That's on the DCHA website. You can see what the voucher really covers. So ultimately, we're never going to apply to a place that the voucher does not cover. Number one, because housing is not going to be allow them to be approved for it. And number two, is that it's outside the range. So when it comes down to it, and when they apply for any house, whether it's a 2-bedroom to wherever the family size is, whatever the voucher size is, it will always be based on what the voucher covers itself. So again, like I said, when it comes to income, if the rent is like, let's just say $3,000, and the client only gets let's just say a utility stipend, they're not even paying a portion at this point. And then if they do have some type of income, then their income is only based off 30% of what their income is. I mean, their portion is only based off 30% of what their income is. So it could be as low as, I got a client that is $6. His portion is $6. You know, so
yeah.
I hope I answered your question.
Yeah, you did. And as you were talking, I was thinking about what the scenarios might be as people make application. I appreciate that. Thank you. We're going to see what we can do to address it. It may be a simple matter of, I guess the easiest way is to not discriminate against a voucher holder. That's the easy way, and to put penalties, in place. But sometimes the easiest way is not the way that we can get it to work. But I appreciate your comment. I'll ask Mr. McCobb and Mr. Locadaris if you have anything that you wanted to add to this discussion at this time.
Yeah, Councilmember, the only thing that I would add is, I think it's important to keep in mind the difference between an eviction filing and an executed eviction. And so much of the records is simply eviction filing, and that can be, and quite often is, as simple as somebody, misses a payment, a filing happens immediately against them, and then they make the payment, right? And that's the end. But that goes, that is then searchable in public record. And so that is, as we note in our report, only fewer than 5% of eviction filings actually end in an executed eviction. And so that's a really important thing to keep in mind is, right, landlords shouldn't be making decisions based on that kind of, right, simple mispayment that goes into court records. And what we found, and what the PhD student from MIT noted earlier, is that landlords often aren't distinguishing between those two kinds of things, right? An actual executed eviction versus simply somebody missed a payment and the landlord immediately makes that filing and they pay their rent and it goes away.
Thank you very much. Mr. Locadaris, do you have anything you want to add?
Yes, Chair, thank you. When I spoke to my members about this legislation, one provision that they were concerned about dealing with not being able to base a prospective tenant's application on credit score. They voiced a lot of concerns regarding a history of being responsible for payments. So that's an area that I know that they have a little bit of heartburn over. I just wanted to mention that.
So in other words, your members feel that a credit rating is indicative of the level of responsibility that individuals take with managing their life, managing their finances? Is that where you, how you
Yes,
see this or how you use this?
yes, ma'am. They, like I said, they communicated to me that they would prefer to see that they can use minimum credit scores, and they believe that is, a big indicator on a prospective tenant's ability to be able to meet those monthly rent payments.
Okay, well, thank you all. Thank you very much. I think we completed this panel. Am I correct, team?
Yes, Councilmember.
All right.
Sam, can
Thank
move
you
out.
all. We're ready for the next panel.
Yes, that will consist, oh, Councilmember, do you want to take a break? We are at the 2-hour mark, and per committee rules, we get to take a 15-minute recess every 2 hours.
Could I get a little water, please? Yes, let's take a 5-minute, okay?
5-minute recess. All right.
All right. Thank you.
Yes. All right, council member, we've hit 5 minutes, so if you want me to call the next panel, I'll go ahead and do that.
All right, we are ready to resume, and I'll call the next panel, or you'll call the next panel. Thank
I'll
you.
call the panel so you can announce witnesses. Okay, so the next panel will be Lauren King, Tysa Kitt, Kate Coventry, Charnel Chaney, Natasha Duarte, and John Blake.
All right, we're ready to start with Ms. King.
Thank you, Chairperson Bonds. Good afternoon, Chairperson Bonds and members of the Committee on Housing and Executive Administration. My name is Lauren B.B. King, and I'm the Housing Initiative Attorney at the DC Bar Pro Bono Center, serving approximately 20,000 individuals each year with our clinics, resource centers, and other programs. The Pro Bono Center is the largest provider of pro bono legal assistance in the District of Columbia. I am here today to encourage you to pass the Eviction Record Sealing Authority Amendment Act of 2021. As an attorney who provides legal services to tenants living on very low incomes, I want to share my experience helping tenants seal their records and to elevate the voices of tenants struggling to find affordable housing in the district. DC tenants living in poverty face extraordinary challenges in obtaining safe, affordable housing. According to the National Low-Income Housing Coalition, there are about 50 affordable units in DC for every 100 renters that qualify as extremely low income. Extremely low income families in the district who cannot rent one of the elusive affordable apartments often rent apartments that cost over 30% of their income, sometimes over 50% of their income. Many of these families must forego necessities like groceries in favor of paying their rent. These cost-burdened families are also more likely to end up in eviction court. Eviction records create an additional and significant barrier to affordable housing. A study by Georgetown University McCourt School of Public Policy, who you've heard from today, notes that landlords often deny applicants based on the mere presence of an eviction filing on their record, regardless of the case's final disposition. In DC, it's extraordinarily easy to look up old eviction records. Unfortunately, these records often lack information necessary to understand why the case was filed. One important piece of information that would provide context is highlighted in the Georgetown study. Large landlords in DC often use eviction court as a tool for collecting unpaid rent, not to actually evict their tenants. Before the passage of the Fairness in Renting Emergency Amendment Act of 2020, tenants had no real mechanism for sealing old eviction cases, especially if they were unrepresented. The presence of old rental records and the negative impact they have on rental applications lead many tenants to accept substandard and unsafe housing as a last resort. When the district enacted the Fairness in Renting Emergency Amendment Act of 2020, my office received a large number of calls from tenants seeking help in sealing past eviction records. I want to share a story with you detailing how the Fairness in Renting Emergency Amendment Act helped one of my clients. Miss B is a mother of 2 children who fell on hard times and was forced to seek housing from one of the district's homeless shelters. After living in the shelter for some time, Ms. B began participating in the district's rapid rehousing program, which pays rent on behalf of homeless families for a finite period of time. In summer of 2019, Ms. B's landlord filed a case against her for $130. She did not receive notice of her first court hearing, and a default judgment was entered against her. The landlord subsequently evicted her over less than $150 in the fall of 2020. Ms. B again returned to a shelter with her children. When she contacted our office in January of 2021, Ms. B was still living in a facility for homeless families. She needed to find an affordable apartment for her family, but was repeatedly denied due to the eviction on her record. And I must note that was an eviction that did go through over $150.
Okay.
Ms. B briefly gave up on applying for housing altogether because the application fees were becoming a financial burden with no end in sight. I helped Ms. B seal the record of her eviction case by filing a motion with the court because her case was not old enough to qualify for automatic sealing. The court granted Ms. B's motion, and now she and her children have a clean slate. She can now apply for apartments with confidence, knowing she does not have an eviction on her rental record. Ms. B is one of the many tenants in the district who are denied housing because of an eviction case on their rental record. Because of the Fairness in Renting Emergency Amendment Act, Ms. B was able to get a fresh start for her family. Passing permanent eviction record sealing legislation will help more tenants like Ms. B obtain safe, affordable housing. I thank you for the opportunity to testify today, and I welcome any questions you might have.
Thank you very much. Thank you very much for your testimony. I think Ms. Kidd is our next witness.
Hi, good afternoon.
Hi, good afternoon to you.
Good afternoon, everyone. My name is Tidy Kidd. I am 40 years old and born and raised in Washington, D.C., where I've lived, worked, married, and raised my two beautiful kids all my life. My daughter, who is 17, and my son, who is 13 and have autism. Even after divorcing, I stayed in D.C., where I'm happy to be raising the fifth generation of Washingtonians. In 2019, my 20-year battle with ulcerative colitis and Crohn's became so debilitating that I could no longer work. We became homeless and entered the Brooks Short-Term Family Shelter in November 2020. With the loss of my work income, we only have my children's survivor benefits from their father, who passed away in 2015, and my son's SSI, which altogether totals about $1,300 a month. I qualify for the DC's Rapid Rehousing Voucher, a program that pays for your housing for 12 months, and I pay 40% of my total income back to DHS, which gradually goes to 60%. But after 12 months, I am totally responsible for the entire monthly rent and fees. Many of the rental housing and apartments want the tenant to pay also all the utilities, trash and sewage fees, pest control, and lawn maintenance fees, in addition to rent monthly. I have receipts to that effect. The truth is, there is no available affordable housing for $1,300 a month. If so, they are either located in very rough neighborhoods or on properties that are owned by slumlords who provide little to no upkeep. Finding an affordable and safe place to live has proven very difficult. That is why I'm here today to share my story about applying for housing. Properties that are nice and in safe neighborhoods are pricey, or they only state that Section 8 certificates, they only take Section 8 certificates, but not the Rapid Rehousing Voucher. If they do, there are stipulations such as you must have a credit score of 640 or above, pass background checks, and your income must be 3 times the amount of the asking rent. In theory, if my income is 3 times the asking rent and I have a credit score of 640 or above or better, I would not be homeless. Let me share 2 of my experiences searching for a place for my family. I was accepted by Channel Square Apartments in Southwest DC by the Wolf for a 3-bedroom, 1.5 bathroom at the monthly rent of $4,069. When I went to view the unit, the building was very old, dark, with questionable characters hanging in the parking lot at 3:30 p.m. The apartment was on the 8th floor with thin floor-to-ceiling windows with the wind whistling through. My son, who has autism, has no sense of danger and will be preoccupied with those windows. My greater concern was being able to afford $4,069 after the 12th month. Though I did not feel the apartment building and unit were worth the amount, that is what HUD guidelines will pay because of their location. I did find a nice 3-bedroom home for rent in the historical Hillcrest neighborhood for $2,850. The neighborhood is quiet and the area is safe. I applied but was denied because HUD guidelines will only pay $2,200 for the Hillcrest neighborhood for a 3-bedroom house. I found in my searching for a place that the nice homes were priced just above what HUD will pay for the neighborhood. I began to wonder if this was a way to marginalize against those who are homeless and have a rapid rehousing voucher. How can I afford all of this on a $1,300 a month, facing my constant health crisis and caring for 2 babies? How can I relax and stop stressing when such worries are ever present? Do these same guidelines go for those with the Section 8 certificate? If I had a Section 8 certificate, would the $2,850 have been a problem then? Would my credit and income have been asked for? The preferred acceptable voucher seems to be a Section 8. Many of the low-income rentals are owned by slumlords and in areas of high crime. When I looked at properties given by the Brooks Shelter case manager, I spoke with several residing in the places I went to look at, and they spoke on how they came through the Rapid Rehousing Program and are having housing troubles. They shared that they have trouble getting their landlords to fix things. Example, one lady said she was without a stove for 2 months. Another said she had caught 9 mice in one night. Several were looking to move because their 12 months were ending, and though affordable, they wanted to leave because of the slumlords and the crime that was around them. I reached out to organizations and city council members for help with finding affordable rentals. In the beginning, many were sympathetic to my trials, but eventually my constant cries for help, accountability, and integrity were just another area. This was made evident by Mr. Gary Johnson, the constituent director, and Council Anita Bonds, Anita Bonds council member office, that told me on the phone, the beggars cannot be choosy. In summary, landlords and developments of nice and decent places to rent find a way to screen out those that they deem unwanted. The rents in DC are exceptionally high, pricing out native Washingtonians who, like me, have suffered the crisis and need a hand up, not a handout. But penalizing me because I won't just take anything to ensure my family and I'll not put back in this same situation is unfair and inhumane. Thank you for your time.
Thank you very much for your testimony. And if you recall, you actually spoke with me also. And I also shared with you the guidelines that the housing agencies use, particularly as it relates to the federal guidelines. So I'm very sorry that they did not work for you, but I don't have any control over that. And I think we had a testimony earlier today from a witness that was encouraging the federal government to take action. And that may be where we need the kind of action that can repair some of these situations we're hearing about today. But I appreciate you coming forward. And I do have another question for you, but I got to move on. So if you'll hold on, I want to ask you about one of the issues that you raised. So thank you very much. And I think we have two more. I know we have two more guests. Ms. Coventry, I believe you're next. Kate.
Thank you,
Coventry. Kate and I go to the same church, so that's why I can say, okay. All right.
Yes.
How are you today?
Good, thanks. How are you doing?
Good.
Hope to see you in person at church soon.
Yes, we all are hopeful.
Thank you for the opportunity to testify today. I'm Kate Coventry. I'm a senior policy analyst at the DC Fiscal Policy Institute. I'm here today to express strong support for the Fair Tenant Screening Act of 2021. It sets tenant eligibility screening standards for landlords, given overwhelming evidence that current tenant screening processes are rife with errors. This legislation is needed to ensure fairness in the process. Research finds high numbers of errors in tenant screening tools. The district should act to protect rental applicants. Tenant screening is the process by which landlords accept and review rental applications to determine whether or not to offer a unit. This bill sets tenant eligibility screening standards for landlords to improve fairness. Other witnesses went through this, so I'll just skip ahead. Requiring reasons and documentations for denials and providing an opportunity to appeal is very important because of the frequency of errors in the records that are used for tenant screening. 79% of respondents in one study found there were errors in one of their 3 major consumer credit reports. 1 in 4 of these errors were significant enough to cause a wrongful denial of credit. There have been dozens of lawsuits against criminal record database companies alleging that their records contain inaccurate information. And state sex offender registries are, quote, notorious for reporting inaccurate and outdated information. Common types of errors include over-reporting, when a record is about a different person but with the same name as the applicant, criminal identity theft, where a person claims to be the applicant, including records that have been expunged, and clerical errors. The bill also requires all applicant screening companies to register in the district and to comply with the above provisions. This is important because although they can research applicants themselves, the majority of private housing providers now purchase tenant screening reports that combine the information cited above that is already riddled with errors. The weight of evidence suggests that the chance of finding significant errors in a tenant screening report is at least as high as the combined likelihood of finding errors in each particular component. And then there are additional opportunities for clerical errors and other mistakes to arise at any time as the agency interprets, repackages, abridges, or modifies the information. This is especially true of scores or recommendations based on criminal and civil litigation records, which may require substantial skills to properly interpret. A particular concern is that some tenant screening reports only contain their opinion of whether landlords should accept or reject the applicant without providing the underlying data. This means that when applicants ask why they received a rejection, the landlord cannot honestly tell them, and applicants have no means of disputing the rejection. Another major issue is that unlike credit reports, applicants have no practical method to check tenant screening reports or challenge inaccurate information prior to applying for housing. Federal law allows individuals to request a free credit report from the 3 major consumer credit bureaus each year, and there is a formal dispute process. In contrast, there are an estimated 2,000 companies that offer tenant screening services, and disputing an incorrect report only affects the report of the company involved. Thus, an applicant may have to challenge the same error over and over again with no way to affect future reports, essentially locking them out of the rental market. Other witnesses before me talked about voucher holders and the sensible parameters this bill sets for them. So I will not repeat myself. That will be in my written testimony. Strongly support B24-106 and urge the committee to work with legal advocates to resolve their concerns. Thank you for the opportunity to testify.
Thank you. Thank you very much for your testimony. And I think we now have Ms. Chansey. I believe.
She was here a minute ago. Oh, here we go.
Oh, all right. Ms. Chansey, you are up now.
Hello, how are you doing this morning?
Good.
Good morning. Thank you very much for your time and for listening to my testimony. My name is Charnel Cheney. I'm a resident of Ward 8 and a graduate of the Community Family Life Service Speakers Bureau. I want to tell you why I support the Fair Tenant Screening Amendment Act and the Eviction Record Sealing Authority Amendment Act. The city is facing a gentrification crisis and the rent keeps going up, leaving hundreds of families displaced or homeless. When you go through the Virginia Williams Rapid Rehousing Program, they help people rent for up to a year. For many people, that year is not enough. If you're not in a financially stable place, then in a year, you are right back where you started. You get evicted because you can't afford the rent, going back into the shelter to do the process all over again. Except now it is harder because you have an eviction on your credit. It will take longer for you to get out of the shelter. By sending people eviction records, you give them a fighting chance to give housing after gentrification has led them to being evicted, or after a rehousing program has failed them. Many people do not know that having an eviction on their credit will stop them from getting housing in the future. And this ignorance can lead them to make choices that will lead them to an eviction. People need a place to sleep at night, and that stops them from considering how an eviction will affect their credit tomorrow. Limiting the circumstances in which a place can charge an application fee will also Limited circumstances in which a place can charge an application fee will also be helpful to many people. While going through the process to find a place, you can find yourself spending a lot of money on application fees just for the place to not be available, or you not get approved based off a previous eviction. It's the waste of money for application fees to not be approved based off previous evictions. Even a small application fee can be a lot for a person that's on limited income. And if you have to apply to multiple places, then those fees add up. I hope to see more second chance programs surrounding housing in an environment where you're not really taught the details of renting, credit, and finances. You have to learn through trial and error. With the current system, any error you make with you stays with you for the rest of your life. How long should someone pay for their lack of knowledge? When the system fails you, that isn't your fault. You shouldn't have to at all. People in difficult situations should feel supported and understood. When bills like these are passed, we feel seen, heard, and cared for. This will help us achieve stable housing and escape the treadmill of homelessness and evictions that too many low-income families get trapped in. Thank you very much for your time and listening to my testimony.
Thank you very much for your testimony. And I think I was wrong. We have 2 additional witnesses, right?
Natasha is here. There's also John Blake who's not here yet, but
All right,
Natasha,
okay.
when you're ready.
Hi,
Okay.
council member. Thank you for allowing me to testify. I'm a Ward 1 resident and a senior analyst at Upturn, a nonprofit research organization here in DC that works to advance justice in the use of technology. I support the Eviction Record Sealing Authority Amendment Act for all the reasons you've heard today, and I'm just going to add 2 additional points to that support. First, I'm going to explain the role of tenant screening companies and why sealing is the best way to deal with them. And second, I'm going to propose 1 change to the bill. So first, I'll talk briefly about the role of tenant screening companies. As we've heard, the mere existence of an eviction in someone's name can effectively bar them from housing opportunities, and screening companies amplify this problem. They scrape eviction records from court websites and report them to landlords, sometimes along with a risk score or recommendation about whether to accept or reject an applicant. And these reports entrench the false idea that any eviction record is a major red flag for a potential tenant. Despite decades of litigation, some companies do nothing to check the accuracy of the records they report to landlords, leading to reporting mismatched records, inaccurate case dispositions, and even sealed records. The simplest and most effective way to interrupt this cycle is to seal eviction records, making them unavailable to screening companies and other data brokers. For these reasons and others, we recommend the council, we commend the council for working to make sealing permanent, and we urge 1 modest but important change. Eviction records should be automatically sealed at the point of filing, as Brian McCabe also testified, rather than after the conclusion of the case. The council has acknowledged that eviction records simply are not reliable indicators of tenants' behavior or ability to pay, and this is especially true of pending eviction filings. They should not be held against people while their cases are pending. Yet, as we heard from Wan Young So's research, landlords often reject tenants with eviction records regardless of their disposition. And eviction filings have an outsized influence, but no legitimate value in the tenant screening process. As Councilmember Silverman said in her opening statement, using unproven allegations to deny someone housing fails the racial equity test. This is especially true of pending eviction filings, which are by definition unproven allegations. Sealing them will immediately help district residents find housing and will not hurt landlords' ability to find tenants who can fulfill their lease obligations. Sealing eviction records at the point of filing is the simplest and surest way to keep them out of data brokers' hands. Data brokers scrape eviction records directly from the court's electronic case record system as soon as they're filed, and those records end up in tenant screening reports and private databases where they can remain in circulation long after the cases are sealed. This has happened in DC. Legal aid attorneys found that Bloomberg Law collected eviction records from the Superior Court's e-access database and maintained them in its legal database accessible to all of its subscribers after the Superior Court had sealed the records. Trying to suppress records once they've been made public is incredibly difficult and often impossible. Other jurisdictions have embraced the importance of sealing eviction filings. We would not be the only one. The California and Nevada legislatures have required that evictions be automatically sealed at the point of filing and unsealed if a judgment is entered against the tenant. The Connecticut legislature recently passed a bill out of committee that would do the same. As others have testified when sealing records, it's important to maintain appropriate access for the parties to the case, the legal service providers, and others such as researchers and journalists. But there are straightforward ways of doing so. For example, the Connecticut bill that I mentioned would provide access without a court order to the parties and to licensed attorneys for representing clients or prospective clients. This prospective clients language is intended to protect legal aid organizations' ability to do outreach and consultations for tenants who may need legal advice or representation. Under the Connecticut model, attorneys would receive a login, giving them access to the docket. And also allows researchers and journalists to submit a request to the court for records for research and reporting. But we heard from Brian McCabe that there is already a good process in place for doing that. This legislation is timely and urgent. The council has an opportunity now to protect residents from the collateral consequences of post-pandemic eviction filings. And we look forward to working together to move this forward. Thank you so much.
Thank you very much for your testimony. And I'll ask, is Mr. Blake, he's here? All right. John Blake, you're up.
Good afternoon, Chair Bonds and members of the Committee on Housing and Executive Administration. I am John Blake. I'm a staff attorney with Zedek DC, which is a nonprofit legal services group headquartered at the UDC David A. Clark School of Law. Although I am a housing attorney at heart, unlike my legal services colleagues today, I'm testifying on behalf of Zedek DC as a consumer protections attorney. Zedek DC's mission is to safeguard the legal rights and financial health care of district residents facing debt-related legal crises. The majority of Zedek DC's clients are women, and nearly all are from DC's community of color. I thank you for the opportunity to testify today on the proposed bills, and Zedek DC supports the goals of both pieces of legislation. Zedek DC represents and advocates for vulnerable consumers in the district, and these bills will have a direct impact on our clients' ability to continue to live in the district. Our team members routinely help district residents with lower incomes whose applications for rental housing is denied based on recommendations by rental screening providers. We also regularly advise, we represent district residents who have negative credit reports, low credit scores. And these reports really often show what we already know, that despite being forced to take on debt to survive, district residents with low incomes struggle to pay bills that are not essential for their basic needs. The existence of these debts, however, are not good indicators of who will pay rent, as tenants often prioritize paying their rent over other payment obligations when money gets tight. I wanted to give you two recent examples of representations that Zedek DC has had. Both were using pseudonyms in order to protect our clients' privacy. The first is a woman that we're going to call Jill, who experienced basically all of the barriers that the Eviction Record Screening Act was designed to address. She's a single mother, a Ward 7 resident, and she ended up with 3 negative rental housing records. She'd been evicted by a default judgment. She had a settled housing case and was able to retain possession of her apartment. She had another case that was dismissed before the initial hearing. And in 2018, she came to us for help with rent arrears in the case that ended in a default judgment. And we were able to settle that debt and get an agreement to have the negative trade line removed from her consumer reports. But she came back to us in 2020 and told us that despite having the debt settled and the credit reporting issue settled, that she was still being denied rental housing in the district. Now, thanks to the temporary eviction record sealing protections passed by the council in response to the pandemic, most of Jill's negative housing records have been sealed. Under the proposed bill, consumers like Jill would be given a chance to move on from these cases that for the housing providers have been settled years ago. Another client, a recent client that we'll call Mary, Ward 7 resident and a mother of 3, was just denied security clearance for a job that she needed because the screening company compiled a report that included an inaccurate housing record. Now, the inaccuracy was how much she owed a former housing provider, and it also categorized the housing case as a debt collection case. In order for Mary to move forward, she's going to have to deal with this record on the rental screening report, both in terms of getting a new job and a new rental. In terms of best practices, currently 7 other jurisdictions, California, Illinois, Minnesota, Nevada, Oregon, Virginia, and Washington, have state laws that either require automatic sealing for eviction records if the tenant prevails, or at least permit sealing by motion. California, Minnesota, Oregon, and Nevada also permit record sealing by stipulation of the parties in settlement or for other grounds by motion to the court. And we strongly believe that the district should join these jurisdictions in ensuring that DC consumers have the ability to move on from these housing records. When the public health emergency ends and various temporary legislative protections cease, our clients are still going to have debt and credit reporting issues that need to be addressed before they're able to fully recover from the economic hardships caused by the pandemic. Robust tenant protections are needed to fill in the gap in protections left by the Fair Credit Reporting Act. And I wanted to mention that because my colleague, Mr. Lukadakis and Mr. Hunter mentioned the Fair Credit Reporting Act as covering all of the territory of the tenant screening bill. And that couldn't be farther from the truth. As a consumer attorney who regularly practices under the FCRA, the FCRA does not cover all of the territory covered by the Fair Tenant Screening Act. Being able to access a copy of your rental screening report and request corrections for inaccurate entries will not ensure that tenants are not denied housing based on inaccurate or incomplete records. The Fair Tenant Screening Act would address this by limiting what can be used to make a decision on whether to rent. I also wanted to identify that credit scores really are more strongly correlated with whether someone is wealthy or poor than their ability to pay rent. And so we thank you very much for taking up this important issue and urge you to pass both the eviction record sealing and the Fair Tenant Screening Bill. Thank you.
Thank you. Thank you very much for your testimony. I think each of you has been pretty clear as to the issues we have with the consumer reports, the credit ratings, and then the denial or lack of acceptance of our vouchers. And so I have that information. I heard a few pieces of information, well, testimony as it relates to making sure that we include opportunities for researchers and for the legal community to have access to the records in the event they need to provide assistance and of course to collect the data. So I think that pretty much covers what we have heard thus far today. Did I leave anything out, Mr. Wren? Or Mr. Blake? Ms. Cheney? Coventry? Those are the only faces I can see now. So, all right, thank you. Thank you all very, very much.
Thank you.
And we'll move to our next panel.
Thank you. All right, Councilmember, the next panel will consist of Taha Shabazz, Venus Little, Robert Cook, Shanetta Shirley, Tanya Smalls, and Terry Acker. And Sam is in the process of moving them into the panelist room.
All right.
Excuse me, just real quick. This is Ms. Kitt. Ms. Councilmember Bonds, you said you had a question for me.
Yes, I do. You had mentioned, and let me please go through this staff before we bring on the other panel. Ms. Kitt, you indicated that when you were in rapid rehousing, you pay 40% of your income?
Well, that's the guidelines. You have to pay 40% of your income to DC Housing Authority. And then after a few months, it goes up to 60. And then by the 12th month, you have to pay the whole, the goal is for you to pay the whole cost of the rent.
In other words, getting you familiar with being a renter again, I guess is how that program works. Just wanted the public to understand why you would be paying 40% when much of the discussion has been about voucher holders that pay 30%. So I just wanted to clear that up. Thank you very, very much. And I hope that we'll be able to help you in some other way. We can't help you with what you want, as you well know, but thank you so much for putting it on the record. I think that's important.
Yes.
Thank you.
Thank you.
Thank you, staff. And we can now bring on the next panel.
So, Councilmember, it doesn't appear that much of this next panel is on, but the first one is Taha Shabazz. I need to give her a call. But in the meantime, the first one I promoted is Pastor Tanya Smalls.
All right. Pastor?
Hello?
Hello, you're up. All right.
Hi. Hi. Great.
How are you doing?
I'm good. I haven't seen you since you was running and asking for votes. How you doing?
Well, I'm around and you know that. So if you want to, beat the horse, okay, good. Nice to see you.
Oh, nice to see you too. Business is business. You know that. Okay. My name is Pastor Tanya Smalls of God's Victorious Church. I have been an advocate for 38 years. I am one of the founders of Parent Watch Inc. with Joe Patterson regarding special needs. And I have a daughter who has fallen on hard times, who has 2 degrees. She has a autistic son and a daughter in the 11th grade. We looking to graduate and she's going to college. All my children have been to college. All my children were raised here. I was raised here. I'm very upset in that I raised my children. You finish school, you go to college, you get married, you have your children, you pay you work, you pay your taxes, or you get a business, which their mother has. And when you fall on hard times, all these services that our good Washington, D.C., and our council people, the different things you all vote on to provide, to service the policies and all to help the people in Washington, D.C. I didn't find that for my daughter. As you know, I referred her to you. I work with the city council. I refer her to you. I've helped many homeless, so I expect my being out here being your hands and feet. When my people need help, just like anybody in my community or my congregation, I expect for them to get what anybody else will get, rich or poor. So she was not able, she was told that the Department of Human Services could not assist her with a Section 8 certificate. What they do to me is they play God with the certificate. They pick who is whatever policies or whatever things they want to go on to, whatever they want to push or whoever they want to help, whoever is on the council or the committee, you can call in a favor. To me, you don't have to call in a favor. You're supposed to have a need. They told her that you have to have a crisis. You in the Brooks. That's uptown off of Wisconsin Avenue. It's a brand new place. Okay, so they said, okay, you have to have a crisis or you have to be out of here by May 28th. And they called her yesterday and said, oh, we got a referral for you to go to House of Roof, which is more or less is an old school and it's a step down from being up in the white neighborhood in a clean and very nice, next to the police station, brand new temporary housing shelter. They told her, they said, if you can't find housing, we know what the situation is. You don't have to worry about being put out. All that changed when we contact you, when we contact Councilmember Mendelson about her not being able to get the services that you all profess are there for the constituents of Washington, D.C. So she's being retaliated against. It is not true that the Department of Human Services cannot give qualified people with the criteria those Section 8 certificates. What I came to you for is, as the councilman at large, with your authority, I know as a leader why you haven't put foot in the situation and said, this is a person who has a health crisis. She goes to the cancer center every 6 weeks to ward off cancer for 2 conditions you're aware of, the city council aware of, DHS is aware of, and I commend Miss BD. She was right on point, and I understand how she's upset and how they passed my daughter from one to the other, and each one, even within the council, say there's nothing more we can do. Your person, Mr. Gary Johnson, he should be fired because he was very ignorant in telling my daughter, he called on your behalf. And he told my daughter, Mrs. Kidd that just finished testifying that beggars can't be choosers. The devil is a liar. If you pay taxes here, you raised here, you qualify, then you should be able to live in a decent place. People who are homeless are not dogs. They're not burdens. Seniors who don't make a lot of money and they need to stretch their money, not dogs. They're not burdens. Because we're black, because we're brown, most of us have been erased from the city. We're not going nowhere. We're holding you, Councilman at Large, Bonds, to stand up for the people, because I remember when I met you, we talked that you were advocating for affordable housing for people, affordable housing, and that people be treated equal and be treated just, and that you weren't going to stand for the racism and the biasness. That's why I told people to vote for you. That's why I voted for you. And I'm holding you to it, and I'm holding you accountable. I'm holding you accountable for Mr. Johnson. He don't know how he break people's spirit. He doesn't have that right. He had no right to tell her beggars can't be choosers. As long as we pay taxes here, we should be able to rent anywhere that we qualify for. Why is it they push your case managers at the Brooks are very nasty and very indifferent, starting with the director, and starting with Friendship, who's above, who asks you guys for grant money, who asks, they're in your budget, who asked the federal government for grant money, and they're not following through. And look all pretty on the website. Look all pretty, I read it. And everything that they said they do, they didn't get no toys for Christmas. It's like that lady said at the Brooks. They didn't get the bus things. You know, everybody's not blessed with the car or whatever to get around. Nobody's holding these people who are supposed to be running to the poor, who's supposed to not be biased, who's supposed to, because they sat down when they wanted to raise up those dinosaurs and said they're going to build affordable housing, and only, do you all know they only take 20 apartments out of 500 and rent to people, and then they discriminate against the rapid rehousing, and they discriminate against the Section 8. I know, nobody's stupid. The city council work together with the federal government, or you all won't get no DC budget. And so that includes HUD, that includes DHA, who gets the checks. That includes the housing, your housing committee. Oversight means to hold accountable. Oversight means to prove you're doing what you say you're going to do. How are they going to put my daughter out on the 28th, which is next Wednesday, because she wouldn't take a $3,500 apartment and she only get $1,300, and it's not to teach you to pay rent. Let me be clear. She pays rent. You can call. I am in Benny Woods. I've been here for October 3rd will be 23 years. My daughter lived with me. All my children have lived with me. They know how to pay rent, pay bills. She has 2 degrees, one in business and one in culinary art. So you're not talking to a welfare mother who doesn't want anything with her life, or no ignorant Black woman. My daughter is very intelligent. Taita Kit, okay? And so she don't need no help with a 30, you pay 30 or 40% this month and 60%. No, that's the greedy being greedy. And the only people that you all are helping to get rich is these Black bougie apartment building owners who don't want to keep up the property. And when you report them to the Department of Regulatory Affairs Housing, I have so many classes, so many people who complain that they get a letter under their door or in their mailbox because they have reported the landlord taking the vouchers or taking their hard-earned money. The working poor is in my congregation. The poor is in my congregation. You would say I'm a poor pastor, honey, but I'm a great advocate, and I stand up for what is right. And I have that right. So no, beggars can't be choosers. I'm not a beggar. I'm, like she said, she don't want a handout. She don't want a handout, Anita Barnes. She wants you to do what you said you're going to do.
Reverend Smalls, I will
Yes,
do all
ma'am.
that I can, but Reverend Smalls, you know, I do not run programs. Okay, I'm an advocate like you. But what I can do is make sure that the programs that we have are working in accordance to what the law says they are to do. Now, that is what we do
Please,
within
hold
government.
them accountable.
Reverend Smalls, you have an indictment against on a number
You know, I
of
have
sides,
I
and
don't have
it's
tolerance
okay.
for foolishness. I'm a leader like you, a leader, and everybody underneath of you represents you. The head, if the head's sick, the
I
body
agree,
is sick.
100%.
So now you said you don't tolerate that, so I'm holding you accountable to it.
I know it.
People that
I
you
know
work
it.
hand in hand with at DHS, at the federal level, at the district level, you have a right as a boss, because I got a right as a boss. You have a right as a council person. You have a right as a committee chairman to call them and say what's going on. I have these people who you say that you can help, and they are being mistreated, and they are being they're not getting the services that you all are supposed to follow through and see that your people do. That's all I'm asking.
And that is a fair request to ask that, Reverend, and that is what we will work to do, and we do it all the time. My concern is that you are indicating the expectation is that somehow we will be able to say to an agency that you must do this when it may not be within their guidelines.
But Ms. Barnes, I'm telling you what's in their guidelines. And I know that the council people before you, Barry, Tommy Wells, I work with him, when they call, they listen. And I know good and well, Ms. Barnes, I know you nice and smiling, but when you got a cause, you speak up. And so I want you to do that same speaking up for my daughter and everybody else that witness on here and the rest of the people that don't even have a voice. You are our voice. And so I want you to call them with your authority. I've got authority. I exercise it when I know it's my right. You've got authority. I want you to exercise your right. That's all I want you to do. Yes, you have a right to call them and say, this is what your guidelines are. I'm telling my people, this is what the guidelines, and they're calling you, and you're not doing what your guidelines follow. You have a right, Anita. I know better, and I know you can, and that's what I'm holding you. Call your people that you work with. These people are in these jobs getting 6 figures, and make them do their job. These case managers that have these people that are homeless, and they sitting on their behinds, and nobody's looking over their shoulder and say, you got 20 cases. Now I've got a daughter who's a social worker. She had 220 cases and was responsible to write down every day. She had to contact them. Every day she had to be in touch with them. Every day she had to do one thing or the other for them. You're not going to tell me that the Brooks and the Department of Human Services cannot hold these people accountable to help the people. The Brooks is over there about empty. If you want to, go over there and have them show you every person that's in there. As long as y'all stay in the office and don't come out and hold people accountable, that's not just you. Everybody on that council, including Chairman Mendelson, who knows me real well with Parent Watch, come out the office. Y'all give these people these budget money. You give them the budget money. I don't even know how to write a grant. I do it from what you and other people donate. So I did toys this year. I've had 2 surgeries. I did toys for 62 families. I serviced 108 children with donations. Where is the money? Y'all giving 10, 20, 30, $100,000, $300,000 to these people, like the Friendship and countless other nonprofits, and they're not doing their job for the people that you send them to. That's all.
I appreciate that, and I certainly appreciate your testimony today. Thank
you for the privilege.
Thank you very much.
Thank you for the privilege, Chairman Anita Barnes. Put foot in the people's tail to do what they supposed to do. It's a shame. It's a shame. And I wanted to piggyback on what the black guy said, Mr. Dean, Maryland and I've had people sleep on my floor. Maryland and Virginia were racist, and you remember black folks couldn't even buy a house or a piece of land out there when we were born. I was born 1953, so a little bit before that black folks couldn't start getting out in Maryland and Virginia until the 60s and the 70s. And my mother, she had a house up there, Ward 4 at 10th and Randolph. Now it's worth $700,000. She's dead and gone. Okay? Now, Maryland and Virginia does not have rental control. That you move in today, they can tell you in 6 months they want you to pay $200 more. And if you can't pay the $200 more, you got to get out. So no, I don't want DC, Councilwoman, I don't want DC to become another Maryland and Virginia, where people have no rights, tenants have no rights, and bigoted, ignorant landlords or racist landlords, and that come in all colors, including my own people, my grandmother marched with Martin Luther King, and my grandmother and her mother picked cotton, so that these people, my color, and you, can sit in these positions. And it's like our people blessed and forget, and it's a shame, and I'm ashamed of him. I don't care whether you like it or not. But God bless you. I know there's other people. I thank you so much for listening, everyone, and Chairman. Thank you so much. And I pray God be with you. Thank you.
Thank you. Thank you very much, Reverend.
I look forward to hearing from you.
Well, Reverend, be sure to call and leave your number, so I'll be sure to get back in touch with you. Don't give it over the airways, okay?
Yes, ma'am.
All right. Thank you.
All right.
Thank you very much for coming today.
God
I
bless
thought
you.
all of your testimony was very, very helpful to us.
Thank you so much.
Sincerely.
I appreciate it. You welcome.
Okay.
Bye-bye.
Bye-bye. And I think, do we have any? I can't hear you. Now we can, yes.
Okay, I went ahead and promoted the last panel since we had so few people from the fifth panel show up. So that is Vivian Mercer, Casey Wong, who's going to be reading the testimony of a person who wished to remain anonymous, Linda Shaw, and Amber Harding.
Okay, Linda Shaw, Amber Harding, Vivian Mercer, and is there anyone else?
Yeah, so Alexis McKinney is here and she's next on the panel 5. She is replacing someone who had previously registered and was unable to come.
All right, I'm ready. Okay, thank you for Ms. McKinney. All right, Ms. McKinney, you have the floor.
Hello, good afternoon.
Good afternoon.
Hello. My name is Alexis McKinney. My pronouns are she, her, and I am a housing organizer at Bread for the City based in Southeast. And so our work at Bread for the City is mostly organizing alongside other mostly Black, low-income DC residents, as well as public housing residents, and combating gentrification in the city. And I know we mentioned gentrification a lot, so I wanted to kind of provide my own understanding of it, which is a violent process in which those with money, mostly white people and corporations, they flock into urban areas, driving up living costs and displacing the original inhabitants, which are usually low-income Black and brown residents. And so as of 2018, DC was the second most rapidly gentrifying city in the entire country. Right. And so that is part of the context in which I bring into this testimony around the Fair Tenant Screening Act, as well as the fact that we have a public housing authority, which has deemed its 30% of its own housing portfolio to be uninhabitable, right? And is now displacing its own residents and providing them with vouchers, which we've had folks testify about the problem with vouchers before. And within my own experience as a housing organizer at Bread for the City, working with residents at Kenilworth in Northeast DC, who are mostly seniors, who we know, or some of you may know, that Kenilworth has been kind of under development, supposed to be changing for the past years now. And they finally started moving residents out, also known as displacing residents, senior residents, Black low-income people in 2019. And so many of those residents had little to no support in finding alternative housing, even with their vouchers, right? They were worried about their credit scores. They were worried about their income levels, even though they had vouchers. And so this act directly impacts that, because we know that eviction records and credit checks disproportionately impact low-income Black and Brown residents who are already being impacted by gentrification. And so within the advocacy department, we operate within a structure of reparations, right? And so this act doesn't even begin to touch reparations, but we have to start from somewhere so that tenants can have a fairer, more equal chance, especially Black and Brown low-income tenants who are already being pushed out, who are already being displaced from within public housing and within the private sector, to have a fair chance to have housing, especially within a pandemic. And so that is my testimony. Thank you.
Thank you very much for your testimony. And now we will hear from Ms. Vivian Mercer. No.
It says that I can't, it says you cannot start the video because the host has stopped it.
We can hear you.
Okay, start my video.
All right, there you go.
Hello, everybody. Hi, Ms. Barnes, how are you? Chairman Barnes.
Good, good, good. Nice to see you.
Great. Good afternoon, everyone. My name is Vivian Mercer, and I'm a native Washingtonian. I'm a longtime resident of Ward 7 and recently been in Ward 8 for the last 4 years. And I'm here today to explain why it's so important to pass both of these pieces of legislation. I wanted to speak about how an 11-year-old eviction, which is still currently on my record, has impacted me physically, financially, and emotionally. This one and only eviction has prevented me from obtaining housing, including in certain government programs, and continues to follow me on every credit reporting and application report. One instance of a lost job and getting behind on bills should not follow someone and prevent them from getting housing for the rest of their life. Protect DC residents from further harm by simply passing the eviction record sealing bill and the fair tenant screening bill. In 2010, I was living in a 2-bedroom apartment on J Street Northeast and paying about $800 a month. I eventually had to take leave from work and began receiving unemployment. At the same time, my rent went up to about $900. I was unable to pay my rent and fell behind a couple of months. I arranged for a friend to help me pay the rent and was working diligently to get the arrears down. I kept personal notes on how much I owed and how much I paid off, but they kept telling me that I owed more money because of the arrears and the late fees. Although I tried to honestly pay what I owed, the property changed management and had no paper trail as to how much I owed. So next thing I knew, I was given a notice for eviction. The eviction impacted my entire life because I was not able to find an apartment for years afterwards. I stayed with my sister for about a year, but that didn't work out because my sister was nosy. She was all in my business. I'm sorry, but that was not a long-term solution. It was difficult to live with her. So I moved around from place to place. I ended up living with my mother for a little over a year, which is when I found out about a transitional housing program. I lived in a 1-room unit at the Willis Paul Green Manor building for 5 years. While I was in this transitional housing program, I applied for a Section 8 voucher, but could not receive one due to my eviction record. I was approved later for an in-house voucher, and I still don't know how that works now, but that single eviction keeps me coming up. keeps coming up on my credit report as an outstanding payment. Even after all these years, I have not been able to get them to expunge or remove this eviction from my credit report. With the Fairness in Renting Emergency Amendment Act, my eviction record almost certainly could have been sealed, but has not been. Because of the uncertainty of how the emergency eviction record sealing is being enforced, people with older records are not getting their eviction sealed. For that reason, it is vitally important that you all work to create a consistent, fair, and uniform system for eviction record sealing. A decades-old eviction on my record should have no impact on my ability to pay my current rent or even get employment in the district. I urge the committee to pass the Eviction Record Sealing Authority Amendment Act and Fair Tenant Screening Act so that tenants are not further harmed by outdated eviction records that do not reflect whether they are currently a good prospective tenant. Thank you.
Thank you very much for your testimony.
Yes,
I have added to our list the sealing of maybe all of the filings that are without cause.
I don't know who I should talk to about the in-house vouchers and the Section 8 vouchers.
I'm sorry, you don't know who to talk to about the what? I cannot hear.
Can you hear me now?
I can hear you a little better.
Oh, I'm sorry. As I said, when I was at the when I was in the one-room unit at the Willis Paul Green Manor building, I wasn't able to get a Section 8 housing voucher, and I was later approved for an in-house voucher, but I don't know how that works. I was told that I can only move to a place where they have an in-house voucher, that I can't move anywhere else. So I'd like to find out more about how that works, and I need to know who should I talk to.
Okay, we will work with you, Ms. Mercer, on that. We'll work with you. So please, would you just get us your phone number so that we can be in touch with you?
Yes, ma'am.
All right. Thank you so very much.
Mm-hmm.
And I think our next witness is Ms. Shaw, Linda Shaw. Ms. Shaw, you're still muted. You have to unmute.
I thought y'all did that. Okay.
Okay, now you're better. We can kind of hear you finally.
Thank you for allowing me to testify today. I'm Linda Shaw, a Perimeter Supportive Housing Case Manager for Metropolitan Educational Solutions. I'm here in reference to B24-106 Fair Housing Screening Act of 2021. Over the last year plus, I have been housing homeless families. During the process, we do what is needed to assist the clients so they're ready to take on the responsibility of renting and taking care of any unit that they may rent. When assisting my clients, yes, I have concentrated more on Northeast and Northwest area of the district. My purpose is to assist the client by giving them chances to thrive and moving them to better areas. I accompany them when going out to units they're interested in renting, and I sell my client to the landlord, the property manager, rental realtor, or broker, whoever we meet at the location. I take the time to explain our program and that as a case manager, I would be part of their lives for the next year that they're renting with them. I share this with you because I want you to know that we tell them we're a part of this. It's not something where we drop them off at the door once they become one of their tenants. I also share that this is a partnership to build a positive relationship between the landlord, tenant, and the case manager. During the time I have searched for units with the clients, there have been several times when the clients were denied and the application was stopped due to the credit score or income. Not an eviction or any other damaging information on the credit report, just the credit score being low due to bad credit or no credit at all. When asked more detail or why they were denied or to talk to the actual person making the decisions, we were denied access. I have been told that there's a lot of owner properties using the data broker companies that do screening for them and use an algorithm to determine if the renter qualifies via the income or credit score. Judging the client's character based on their credit score is not right, nor is it show empathy for those that have been hit hard by the pandemic and any other life changes. The income should not be the factor for voucher holders if the unit is rent reasonable. because as part of the voucher program, the client pays a small amount, as been said earlier. The district determines what they're required to pay based on their income, and the housing pays the bulk of the rent. And the last time I checked, the district had A1 credit. One client especially comes to mind when we talk about this. This client was complying with the program's guidelines and the requirements. We had searched for units for several months and found the perfect home for this client and her 4 children in a quiet and safe area in Northeast. It was across the street from an elementary school, and it had enough space for her and her children and a large backyard that was fenced in. It also had a finished basement which she can use for homeschooling during the pandemic. As we started the application process, the person showing the unit asked what her credit score was, and she told them. She was also shared that due to she was also told that due to the fact that her credit score was low, that she could not rent there. She also shared that her credit score was low due to no credit, not no bad credit. They then told her that she may not want to submit any application because of a waste of her $75, because they were only accepting tenants with a credit score of 650 and above. This was heartbreaking. There was nothing on her credit report, which we had reviewed earlier, that showed that she had anything bad, like an eviction or anything damaging. The client had been on the program for over a year, an affordable housing program we had, and she had been paying her rent on time. She was a good renter. To try to assist with this decision, I told the landlord about the Landlord Partnership Fund, which is a program that's in the District of Columbia that assists with tenants that may not pay the rent or do damage to the property. Nothing I said made a difference. I'm asking for a few things to happen, Ms. Anita Bonds. One, that the use of credit scores of a potential renter be exempt. We want to stop them from being used to determine the character of a client and their ability to pay their rent. Also, if a client has a voucher or is on a voucher program, we want it to be known that the district handles and pays the bulk of the rent, and that it's only based on their income and not if they could, the income of actually to pay the whole rent of the unit, and is paid by the district. I want to make sure that we assure that the person owning the unit knows the rules and guidelines, and to hold them accountable. Because whenever I've actually talked to them or tried to, have a back and forth conversation with someone that's denied someone, I've not gone any further than the person showing the unit. I want to be able to have a number which I can contact at the time when I'm at the unit, which is available any hours we call, so someone can talk to them when they talk about them violating the guidelines or the tenant's rights, to be able to get them face to face at that time. So right now where we are, I want to do whatever I need to do to help to move this bill forward.
Thank you. Yeah, no, thank you very, very much.
It is written. I got it written
I'm
up for you. I can
steadily
send it to
adding
you.
to our list of things that we want to make sure that the bills contain. Thank you very, very much.
You're quite welcome. Thank you.
And we have one or two more.
Yes, Councilmember, we actually skipped over accidentally one person who wishes to remain anonymous, but Casey Wong is here and will read their testimony into the record.
Okay, who is here?
Casey Wong. She's reading.
Okay, Ms. Wong. Okay, Ms. Wong.
Hello, my name is Casey Wong, and my pronouns are she, her. I'm a housing advocacy coordinator at Bread for the City. Thank you for holding this meeting. I'll be presenting anonymous testimony. The city
Ms. Wong, can you kind of speak up a little bit? Your voice is fading.
Yes, of course.
now we hear you.
Thank you. So I'll be presenting anonymous testimony for a Bread for the City community member today, beginning now. Hello, I am currently living in hotels and have been housing insecure since 2016. I am sharing my story with the committee to urge you to pass both bills being heard today. In 2016, I was a student at UDC and living in a one-bedroom apartment in Ward 5. I was paying my rent, attending classes in the day, and working as a patient care technician at Washington Hospital in the evening. A situation came up at work that required me to change my work schedule. After 3 months, I was told I could no longer work the night shifts. Thus, I could no longer pay my rent. I ended up applying for loans to stay afloat. Eventually, I received a notice for eviction, and so I went to the court hearing and said I would pay what I owed. At the time, I knew in front of the judge I could not pay what I owed, and soon I lost everything. I was in class at UDC when they evicted me and towed my vehicle. I was told I had to pay $800 to get my car back, which I could not pay. I lost many important personal documents and was directed to a shelter by Bread for the City. I continued attending my classes and coming back home to the shelter. Living in the shelter was horrible and the staff treated me poorly. At the time, I continued looking for a job that had night shifts. Unfortunately, I was kicked out of that shelter and moved around a few times to various other shelters. After a while, I could not handle living in those shelters any longer, and so I loaned even more money and started living in a hotel, paying $80 to $90 a night. In the past 5 years, I've applied many times for housing, but I was denied every time due to the eviction 5 years ago. The application process was very difficult as they were not transparent. I was constantly told I would hear back, but had to follow up every time. Once they screened me, they would deny me based on my credit report and my eviction record. I can no longer continue living like this. My GPA is being impacted. My belongings are still in storage and I'm living in hotels. My graduation date has been delayed as a result of the stress and insecurity caused by my loss of housing. Yesterday, I was notified that my eviction records have finally been sealed thanks to a team of pro bono attorneys. This will help me to rent again, to continue my education, to live a better life, and to help someone else. I am relieved and grateful to be able to apply for housing so I can continue my education and my work. Many people do not have access to legal representation to seal their records. We must have a fair and complete eviction record sealing process, and I urge the committee to pass both the Eviction Record Sealing Authority Amendment and the Fair Tenant Screening Act so that one loss of income that resulted in an eviction does not create a lifetime of harm and housing insecurity. Thank you.
Thank you very much for your testimony. Next, we have Ms. Amber Harding. Oh, good. All right.
Good afternoon, Councilmember Bonds. My name is
Good
Amber
afternoon.
Harding. I'm an attorney at the Washington Legal Clinic for the Homeless. I'm testifying in strong support today of the Fair Tenant Screening Act and the Eviction Record Sealing Authority Act. Since 2015, I've led a work group on eliminating barriers to rental housing for DC residents experiencing homelessness. This work group was created when the Interagency Council on Homelessness recognized that restrictive or unfair housing eligibility policies and practices were interfering with efforts to end homelessness. At our first meeting in September of 2015, we identified credit, rental history, criminal history, and voucher discrimination as the most prevalent and significant barriers to rental housing beyond affordability. We learned quickly that many landlords are relying on background screening companies to tell them whether or not they should rent to an applicant, often with near total deference to the recommendation, and that there is very little transparency to their business practices, including what data they are accessing and how they rate applicants. In the fall of 2019, the Legal Clinic held more than 8 community sessions with hundreds of people who are homeless to learn what was keeping them from finding a home, besides affordability. We heard about minimum income requirements set at a level that would screen out any person renting with a voucher or rapid rehousing, exorbitant fees that are impossible for low-income renters to pay, including application fees of up to $120 per adult household member, up to $300 holding fees, and amenity fees of $1,000 or more. Landlords who don't tell applicants what the eligibility standards are and then deny them for broad reasons such as credit. Applicants denied for having eviction cases on their record, even if they won their case, it was a mistake or they never got evicted. Applicants denied because the background screening company recommended they be denied or concluded they would not be a good tenant without any detail provided, and widely divergent standards for screening, little to no transparency or accountability for eligibility determinations. Many landlords use credit or rental history, minimum income requirements, or exorbitant fees as pretext to deny people housing based on race, family size, disability, source of income, or other protected classes. The lack of legal restrictions give landlords near carte blanche to use opaque, arbitrary, or unreasonable standards as cover when bias is the real motivation. But even when landlords carry no conscious bias towards low-income housing applicants in DC, the majority of whom are Black, using credit or rental history as a blunt tool to deny applicants compounds the racism that is inherent in both credit and eviction systems. Credit scores and history reflect a systemically racist system that includes predatory lending, denial of opportunities to build credit, and other racist practices. And as a recent study on DC eviction showed, landlords disproportionately target Black DC residents for eviction. We believe that the Fair Tenant Screening Act and the Eviction Record Sealing Authority Act combine to establish a more fair, less discriminatory system for renters in DC. Working together, the two bills limit what landlords can see and prohibit them from using information that is irrelevant to whether someone will be a good tenant. To be clear, these bills are at their core civil rights bills, which is why the Office of Human Rights is charged with enforcement. OHR enforces all other fair housing laws, including the Fair Criminal Record Screening Act, which recognizes that criminal record is often used as a proxy for race, just like credit and rental history are. If these new bills require DHCD enforcement, on the other hand, prospective tenants would have to file cases with two different agencies if the applicant did not know the reason for denial, if the reason was pretextual, or if the landlord had mixed motive or based its decision on more than one law's prohibited factors. We look forward to working with the committee on the following: reconciling these two bills into a cohesive system, ensuring both laws are easily enforceable by the Office of Attorney General, in the court, the Office of Human Rights, and with a full range of penalties and damages, and that OHR has the resources it needs to effectively enforce the law, exploring sealing more records earlier in the process, making the sealing process easier for pro se tenants, limiting even further what landlords can use to screen applicants, including excluding court records from consideration entirely, which New York does, prohibiting landlords from using conclusions or recommendations by background screening or credit reporting companies related to the fitness of prospective tenants, including credit and risk scores, capping application fees and prohibiting any mandatory fee other than application fees and security deposits, adding a first-in-time rule so applicants are assessed in the order in which they apply, and other technical amendments. And I want to note, because I've listened to everyone's testimony today, that small landlords are actually exempt from the Fair Tenant Screening Act because it's an amendment to the Human Rights Act. And if you'd like, I can go over a little bit of how income and vouchers work together, because I know there was some testimony about that and you had some questions. But that's it. Thank you.
Thank you. Thank you very much for your testimony. We have your testimony, I know, in writing. If you want to expound a little bit, we're here. So go right ahead. Or if you want to send us something in writing more, that would be appropriate as well. So thank you very much.
I can explain the income issue if it's helpful.
Yes, yes, that would be very helpful.
So one of the problems is when somebody rents with a voucher, you asked earlier, is the income, is the amount of the voucher used as income by landlords, which is how the law is sort of written right now. The problem is, there are a couple problems. First, when somebody applies with a voucher, they actually don't know the amount of rent they're going to pay until they lease up. So at the application point in time, the landlord can't say, oh, DCHA is going to pay $1,000. They haven't figured that out yet. They haven't processed that paperwork. So you can't do it that easily. But it's also, it doesn't make sense to add, let's say the rent is $1,500, I pay $500 and the government pays $1,000. If you just add $1,000 to my income, I'm still not going to qualify under most minimum income standards, because that's not really how income works. Like, rent is supposed to be a portion of your income. And so no matter what, when I have a voucher, I'm always paying 30% of my income. So you don't need to ask what my income is. You know that my rent, that I will always be able to pay my rent. If you had to come up with a formula landlord should use, you have to come up with a formula that was 3 or 4 times the amount of the rental subsidy, because that's how rent is, that's how affordability is determined, right? You wouldn't just have the dollar for dollar amount that a voucher pays, because that's not actually how you figure out. You'd have to have 3 or 4 times that. So that's why it's complicated, but it's unnecessary, because you know that no matter what, if my income goes down to 0, the government's going to pay my rent. If my income goes up, I will pay my rent. There's no reason, there's nothing that knowing my income tells you about my ability to pay rent, because I will always be in affordable housing when I have a voucher. I will always pay a portion of my rent. Does that make sense?
Yeah, well, yes, it does. And as you were speaking, I was thinking that one of the steps, the next steps I believe we can follow is to do a quick a meeting around these different issues that have been pointed out. And I think that we are going to have consensus in the process. And then we'll have a so-called omnibus bill that will address these issues. And sounds like one of the main issues we need to address is how do we handle the voucher per se. So
there's a separate standard in the Fair Tenant Screening Act for what landlords can look at when someone has a voucher, because that makes sense. And so there are other things too, like if I have a non-payment of rent case from a year ago, but now I have a voucher, it's not really relevant. There's been like an intervening thing that happened between my non-payment of rent case and my current rental history. So like that's the effort. The Trayon White is the one who worked with us to create this bill. The effort was to come up with something that was rational, considering people who have vouchers, so that landlords wouldn't keep coming up with new ways to deny people vouchers, because they learn over time how to come up with new standards and different ways of denying people that will result in screening people out. But I will say that there is a really active group of community folks and lawyers who have been working on these bills for a long time. And we have an extensive red line for you that we will gift wrap and provide to you that resolves a lot of the issues that I think have been raised today.
That would be very helpful. And I guess as you're speaking, it seems to me we may be at a point where the outlawing the use of vouchers in consideration may be in play. So that's where my head is. And that's what we have actually heard today through this very generous testimony. So I look forward to working with you to see what we can come up with, but we want to do it quickly. We don't want to, waste a lot of time, because, time is so precious now for our community, just in general, and certainly for those that are in this situation where they worry about evictions. And so we want to do what we can very quickly. So I want to thank I think this is the total of our public witnesses. Is that correct?
Maybe one more. I'm going to add someone as a panelist that I think is using a different screen name and try to sort this out here. There's one witness we did not get to, Shanetta Shirley, and I add Ms. Carter, who I've been talking with via email, as a panelist to see if that's the account Ms. Shirley is using.
So do we have anyone else? Do we have Ms. Shirley?
I think so.
Okay.
Yeah, Shirley is here.
All right, Ms. Shirley. The floor is yours.
Good afternoon. My name is Ms. Shanetta Shirley. I'm from Ward 8. I want to take the time out to thank City Council Committee for allowing me to speak and testify. I'm very much supportive of these two bills, and it's very imperative that these bills be passed. I speak as a person whom was evicted due to a case worker and whom wrote an eviction letter on my behalf, in which I did not authorize. Due to the circumstances, I was incarcerated. I'm speaking on the application fees, and it's very expensive for a person with low income. I also want to speak on the fact that I'm a person whom suffer from my apartment being broken into. And when I go out to search for new residents, I get stuck with the fact of credit, income, and background checks. This has brought barriers for me and also for other peoples in whom is a voucher holder. Because of these barriers I mentioned before, it's a struggle trying to find residents outside of these barriers. Me, when I have up to July 27th of 2020 to find new residents. I want to thank you again for allowing me the opportunity to speak and testify.
Thank you very much, Ms. Shirley, for your testimony. You're very, if I understand correctly, you're very concerned about the credit and income checks that seem to be required. And gotcha. Okay. All right. So I heard you loud and clear.
And when it
Do you
comes
want to,
to
you can go ahead and add. Yes, you have
when it
time.
comes to the first screening app, and I didn't have done my research on that. They do is like in the background history, your background. When you have a voucher, you see what I'm saying? I feel as though that should not be your background. People have committed done a lot of things in their back in steps in your life, but if you have a voucher, you shouldn't. It shouldn't be based on that. Your income, if you have no income, your income is your voucher, because housing is paying for it. When it comes to your credit, I don't measure credit cards or anything, but my credit is my credit. It's not my fault that my credit got messed up, but it is what it is. But my thing is, but the credit and the income and background is everything all in one. That's the struggle. That's the barrier right there.
Thank you. Thank you very much for your testimony.
You're more than welcome.
Do we have another witness?
That's all, council member. Now, we could probably take another break before we move on to government witnesses.
Okay, so that's it for our public witnesses?
Yes.
All right, I really want to thank them very much for coming forth today. Sometimes talking about these subjects are not easy, but I'm so happy that we heard from many parties who not only are advocates, but hearing from persons who are engaged in these struggles is very, very important. So I thank you so very much for that. We're going to take a 10-minute break. And I hate to do this to the government witnesses, but we'll come back in about 10 minutes and then we will hear from our government witnesses. I think we have 3 witnesses, is that correct? Okay, we will hear from Polly Donaldson, the Director of the Department of Housing and Community Development, Johanna Shreve, who is the Chief Advocate for the Office of Tenant Advocate, and Kate Velach, who is the Assistant Attorney General for the Civil Rights Division of OAG. So I wish we had the Department of Human Services here, but we will suffice just thinking about the agencies that were mentioned today. So if you guys would just give us a few minutes, we'll get started and hopefully get through this soon. Thank you so much. All right, thank you very, very much for that quick break. And staff, are we ready to continue?
Councilmember.
All righty, thank you very much. We are now going to call forward our government witnesses. And our first witness is Director Polly Donaldson of the Department of Housing and Community Development. And thank you for being here. Welcome for being here. And if you would raise your right hand so I can swear you in, we'll get going. All right, do you swear and affirm that your testimony and any statements made before us today to be truthful and complete?
I do.
Thank you very much. And you may proceed.
Thank you, Councilmember Bonds. I must say I've been on since the beginning and heard all the witnesses, and I'm delighted that you're here, that you convened this hearing, and that I have the opportunity to testify. So thank you. Good afternoon, Chairperson Bonds and members of the Committee on Housing and Executive Administration. I am Polly Donaldson, Director of the Department of Housing and Community Development. I am pleased to appear before you to testify on behalf of Mayor Bowser on B24-96, the Eviction Record Sealing Authority Amendment Act of 2021, and B24-106, the Fair Tenant Screening Act of 2021. It is DHCD's mission to produce and preserve affordable housing for low and moderate income residents and to revitalize underserved neighborhoods in the District of Columbia. As part of this mission, the rental administrator is part of the Housing Regulation Administration within DHCD and is responsible for administering the Rental Housing Act of 1985, DC Law 6-10, as amended, which is codified at DC Official Code 42-3501.01 and what follows. It is for this reason I am testifying before you today. The Eviction Record Sealing Authority Amendment Act of 2021 expressly amends the Rental Housing Act. For its part, the Fair Tenant Screening Act only references the Rental Housing Act in its definitions, but my testimony will argue the purposes and intent of the bill before you makes the Rental Housing Act a better home for its provisions than the Human Rights Act of 1977, as is currently proposed. The Office of Human Rights agrees. B24-96, the Eviction Record Sealing Authority Amendment Act of 2021, is the bill that is relatively unchanged from when I testified on this bill last council session, and I will largely reiterate my testimony during this hearing. The first change proposed relates to the notice requirements of the eviction process. The HCD is directly involved in the eviction process through the recordation of, quote, notices to vacate, which are generally required to be served on the rent administrator as well as tenants. Notices to vacate for non-payment of rent, however, are explicitly exempted in the Rental Housing Act from this filing requirement. In addition, many tenants unwittingly waive their right to a notice to vacate for non-payment of rent when executing their lease agreements. This legislation would amend the Rental Housing Act to prohibit a housing provider from filing a Superior Court complaint to recover possession of a rental unit for the non-payment of rent unless the housing provider has provided the tenant and the rent administrator with a written notice to vacate 30 days prior to filing any eviction case with the court. A favorable feature of the bill is the added requirement that a housing provider must prove that the housing accommodation is properly registered before an eviction complaint may be filed with Superior Court. The core of the bill, as the name suggests, deals with record sealing. One of the biggest impacts of an eviction claim, whether or not it results in a formal court-ordered eviction, is that it can put the tenant at a disadvantage in renting another home and affect other opportunities such as borrowing and employment long after the claim was filed. This bill requires the court to seal eviction records after 3 years as a matter of course. If the claim is unsuccessful, however, the record must be sealed after 30 days. The legislation would also authorize the court to seal the records of certain other eviction claims before 3 years after a successful motion by a defendant. Finally, the bill would add discrimination in housing based on a person having a sealed eviction record to the Human Rights Act of 1977. Today, I am testifying in support of this legislation, but there are important considerations we strongly encourage you to address. First, as a technical point, we ask that the legislation specify that the period after which eviction records are to be sealed as 3 calendar years to comply with the statute of limitations for real property. Second, in addition to contributing to the public record on evictions, DHCD believes that the data the agency receives as a result of all notices to vacate being filed with the rent administrator will be invaluable to our efforts to understand and shape the impact of anti-eviction and other policies. It appears, however, that the notices recorded with the rent administrator and their information value are something of an afterthought in this bill. Most importantly, the bill does not reference them in any record sealing or fair housing provisions of the bill. If it is the council's intention to not allow these records to be used for tenant screening and discriminatory purposes, we recommend that the bill explicitly state that after 3 calendar years, the district too can no longer release or publish notices to vacate, and data from the notices can no longer be released publicly except to the defendant or for research and policy purposes, and then only with any personally identifiable information removed. In general, the council may want to consider how the important policy and research value of these data can be accommodated. The third consideration is that this bill will greatly increase the volume of notices to vacate processed by the rent administrator and will also greatly increase the request for file retrieval on her office. In the year prior to the declaration of a public health emergency due to COVID-19, from March 1st, 2019 to March 1st, 2020, the HRA, the Housing Regulation Administration, processed 2,117 notices to vacate. These did not include any for non-payment of rent, which, as noted above, are currently not required to be filed with the rent administrator. Now, non-payment of rent, however, is the major cause of eviction cases. A recent report from the Georgetown University McCourt School of Public Policy cites an average of 32,000 eviction cases filed in court on average in recent years in the district. Thus, we might anticipate up to a 15-fold increase in the volume of notices to vacate registered with the Rental Accommodations Division, RAD. Currently, the staff must manually review and log submissions, even while primarily working off-site. Moreover, while the Office of the Tenant Advocate expects to deliver an online form submission system to DHCD this year as part of the process, and as a result of legislation passed as part of the fiscal year FY 2020 Budget Support Act of 2019, every housing provider will be required to register with the rent administrator within 90 days. Therefore, the department will not be able to absorb these costs, and there will be a significant fiscal impact from this increased workload for some years to come. Adding to the strain, despite our best efforts to provide rent and other assistance, there may be an uptick in eviction actions over historical norms this fall and winter with the end of the declared public health emergency and local and federal emergency eviction moratoria. I simply want to flag these converging demands on the rent administrator, even as I assure you that DHCD will do its best to meet these competing demands. The fourth concern I will highlight today is that while the court is directed in the new section A-1-3 to dismiss a case when the housing provider did not provide the tenant with notice as required by this legislation, the legislation actually requires notice to be served to both the tenant and the rent administrator. And as discussed above, serving the rent administrator provides a check on the process and an opportunity for public information about evictions and the targeting of eviction prevention services to tenants that receive a notice. To assure that housing providers fulfill all the purposes of the legislation, we suggest the language in this paragraph be modified to read, "did not provide notice as required by this legislation." In this way, it will be clear that both notices are required. In addition to the considerations I have raised thus far, the District of Columbia Office of Human Rights notes that with respect to amendment of Section 221 under the Human Rights Act, Council may wish to insert sealed eviction record to the list of protected traits in subsection A5, as well as subsection B. Additionally, OHR cautions that specifying non-disclosure of a sealed eviction record under subsection G2 could be read to exclude a prohibition on disclosures of other protected traits. In other words, as written, it may be argued that the statute only prohibits disclosure of a sealed eviction record and that an applicant could be required to disclose their race, religion, or gender. If there are any questions regarding these particular suggestions, OHR stands ready to work with the council. With these concerns addressed, we believe of the provisions, the Eviction Record Sealing Authority Amendment Act of 2019 or 2021 will contribute to housing stability and a well-functioning rental market in the District of Columbia. I will now turn to the Fair Tenant Screening Act of 2021. This bill contains a number of important provisions. However, as my colleagues at the Office of Human Rights noted in their testimony when a previous version of this legislation was considered on October 27th, 2020, we believe the legislative provisions belong in the Rental Housing Act rather than in the Human Rights Act. The Fair Tenant Screening Act expands the rights and obligations of tenants and housing providers and seeks to regulate the landlord-tenant relationship and transactions. One such expansion is the tenant's right to receive written screening and admission criteria in advance of a housing provider collecting an application fee. And when a housing provider denies an application, the housing provider must send a notice of denial with an explanation for the denial, along with any supporting information. In addition to regulating fees and other provisions, the bill also restricts what information a housing provider may require from prospective tenants. One such restriction is that a housing provider may only inquire about certain past housing actions. Another is a restriction against inquiring about rental history, as well as income levels and credit scores for tenants seeking to rent with an income-based assisted subsidy. Finally, the bill seeks to regulate background screening companies with respect to registered agents. The district is proud to have the nation's most expansive fair housing law. As an anti-discrimination statute, the Human Rights Act prohibits housing providers from treating individuals differently based on any of 18 identified protected traits. Under the Act's protection, a housing provider may not refuse accommodation or provide services in part or in whole due to an individual's protected trait. The district also has a comprehensive set of tenant protections contained in the Human Rights, in the Rental Housing Act, administered by the rent administrator, which works in conjunction with the Human Rights Act. The Rental Housing Act regulates everyday housing transactions between tenants and housing providers without specific reference to the protected traits in the Human Rights Act. The provisions of the proposed Fair Tenant Screening Act expands the rights and obligations of tenants and housing providers in general by requiring housing providers to issue certain notices and regulating what information they may request from applicants and tenants. But the bill does not prohibit any conduct as discriminatory based on the protected traits under the Human Rights Act. Rather, this legislation appears to be a regulatory scheme designed to manage the mechanics of any landlord-tenant relationship, which makes it a departure from the anti-discrimination provisions of the Human Rights Act. The Rental Housing Act, however, does handle such provisions and regulates other tenant disclosures, including, as discussed above, eviction. Thus, the Rental Housing Act is the appropriate home for these protections. This is more than a legal nicety. There are benefits from an operations perspective from placing the proposed protections in the Rental Housing Act. The Office of Human Rights, which adjudicates contested discrimination complaints, is not well suited to be a compliance agency regulating routine business transactions, such as the daily operations of housing providers and their transactions with tenants and prospective tenants. That function is already handled by the rent administrator. Having all the business transaction requirements regulating the customary occurrences of the landlord-tenant relationship in one statute administered by a single office and agency assists housing providers and tenants in compliance and provides consistency in policy and implementation. It is important to note that while the provisions of the Fair Screening Act can be transferred to the Rental Housing Act fairly smoothly, and I strongly encourage you to undertake this change, substantive revisions will be required to establish enforcement authorities between the rent administrator, Office of Administrative Hearings, and the DC Superior Court, including each adjudicatory body's ability to assess remedies. The rent administrator and her staff can assist in identifying these necessary revisions. Another important consideration is that the Corporations Division at the Department of Consumer and Regulatory Affairs, or DCRA, is responsible for regulating businesses and their registered agents. The current Fair Tenant Screening Act provisions assign parallel responsibilities for this to DHCD when it comes to screening companies. Regulating registered agents is outside the rent administrator's regulatory purview and would require the creation of another facet of regulation and compliance. It also raises questions such as what occurs if the registered agent listed with DHCD does not correspond with the registered agent for the same screening company listed with DCRA. Here again, to facilitate compliance and accountability and to avoid duplicative administration, it makes sense to assign these responsibilities to DCRA's Corporations Division, the part of the district government that currently handles these issues. Summing up, there are a number of important protections and clarifications contained in the Fair Screening Act that have real merit, but as written, it will make operations and compliance duplicative, overly complicated, and potentially limited. To achieve the bill's aspirations, it would benefit greatly from a review and a recasting, placing its provisions within more appropriate places within the existing statute and government structures of the district that handle these matters. We are committed to working with you, Chair Bonds, and the committee to achieve this potential. In closing, I will note that DHCD have identified a number of technical concerns related to vague terms, further specifying timeframes and other issues. For example, the prohibition on considering an action to recover possession should be extended to 3 calendar years to match the statute of limitations in real estate, the provisions of the Record Sealing Act, if those also become law. I ask that you work with the rent administrator to address our other technical concerns as well. I would like to close by noting that DHCD also supports community-based organizations from our federal Community Development Block Grant, or CDBG, funds to provide tenants with housing counseling, and addressing eviction and its aftermath are central to this work. We also support affordable housing programs to protect tenants from eviction and displacement. Recently, DHCD used CDBG and other federal resources to establish 2 COVID-19 related emergency rental assistance programs, which complement the longstanding Emergency Rental Assistance Program, or ERAP, to provide tenants with housing stability and stop the threat of evictions. And of course, we are very involved in implementing the new Stay DC program together with our colleagues at the Department of Human Services, at DEMPED, and at the Deputy Mayor for Health and Human Services as well. Along with our formal role in the eviction process, which would be expanded by this bill, DHCD has significant mission and program interests in reducing evictions so tenants, property owners, District of Columbia citizens reap the benefits of increased housing stability and a well-functioning rental housing market. Thank you, Chair Bonds and the members of the committee for the opportunity to testify today. This concludes my testimony, and I would now be happy to answer any questions you may have. Thank you very much.
Thank you. Thank you very much for your testimony. I must note that you raised a number of provisions that are contained in both bills that would cause us to understand that we may be moving towards an omnibus bill that would address these issues. So I appreciate that. You sort of buttressed that earlier argument. I really appreciate that. But you also raised a number of issues, procedural issues, process issues. And so I want to be very careful in understanding the direction that you are recommending here. On one hand, you're indicating that we need to make sure that the filings regarding companies that may, as I think some of the witnesses, early public witnesses said, that extract the information about from a filing and examine a person's rent worthiness and then use it, sell it on. And so you're saying that DCRA already does some regulation of these entities. Okay, just want to make sure that I understood that. And then I had a question about where your discussion about the appropriateness of the Rental Housing Act as utilized through the Rental Housing Commission. It's my interpretation. Are you indicating? I'm trying to find out. Are you indicating that instead of the Human Rights Office as a placement for the management of this process, it should be in the Rental Housing Commission?
No, the Housing Regulation Administration is part of DHCD. The Rental Housing Commission is separate and independent, of course, as you know. The rent administrator, though, oversees the Housing Regulation Administration within DHCD. And we believe—
All right, I just want to make sure.
Yes. It's the rent administrator, not the Rental Housing Commission.
All right, thank you very much for that clarification. Wanted to make sure I understood that. You also bring up a budget question. You're talking about need more staff resources. And I hope that if we are able to get this legislation through, do you have some indication of what the burden might be, additional burden on the agency?
Yeah, I don't have a dollar figure, but we're already looking regarding staffing and shifting some positions, especially because we do anticipate, as Advocate Shreve will no doubt address, the database coming from OTA later this year and into the beginning of FY22. And so we know that we are going to have to, so we're already planning and gearing up. I'm just saying this adds an additional activity, but one that is very much related to the work that the Housing Regulations Administration and the rent administrator do. So, I mean, I just wanted to flag it though, because there may be, we may need to recalculate based on how this legislation proceeds.
All right. And then finally, when we are talking about these, the two bills, I believe it does also require notification to the Office of Tenant Advocate. Am I correct, or am I thinking about another bill? We have 5 bills we're trying to get done.
Yeah, I'm not, as I said in my testimony, I know of the requirements to the rent administrator and to the and the Office of Human Rights, but I know that I don't know that I don't have a reference to whether the tenant advocate also. So
okay,
perhaps
all right.
The tenant advocate can address that.
All right. Well, Ms. Shreves is with us, so we will be able to ask her that question.
Sure.
Thank you.
Look forward, Council Member, we look forward to working with you, and I know our staff teams have been talking about this already. And yes. I think that, I think these are protections that are absolutely needed. I think we are going to be facing a absolutely unique situation when the public health emergency ends and when the moratoria end. And this is the time. So I think it's very appropriate for the council, for this committee and the council to move this forward. We just have these, as I said, some substantive and jurisdictional questions, but also some technical changes that we would, the rent administrator and I would very much like to participate in conversations with you on.
Yes, and I'm looking forward to your input. Thank you very, very much.
Thank you.
We may have a follow-up question if you don't mind.
I'm
You've
here,
been here all day with us, so
that's right. Yeah,
I'm
here.
Thank you.
I'm in the office, nice and comfy. Thank you very much.
Thank you very much. Well, now, audience, I'd like to turn to Johanna Shreve, who is our Chief Tenant Advocate from the Office of the Tenant Advocate. And so, Ms. Shreve, thank you very much for joining us today. We're looking forward to your testimony. So you have the floor.
You want to swear me in first?
Yes, you have the floor. Okay, you came forward. I had to bring you forward. At least that's what I'm seeing here, yes. Let me get my notes because sometimes I forget to say it right. Okay, you raised your right hand. Do you swear and affirm that your testimony and any statements that you make today to be truthful and complete?
I do.
Thank you very much. And of course, you can begin when you're ready.
Thank you, Chairperson Bonds, and good afternoon to you and members of the committee and staff. I am Johanna Shreve, Chief Tenant Advocate of the Office of the Tenant Advocate, and today I am offering my support for Bill 24-96, the Eviction Record Sealing Authority Amendment Act of 2021, and Bill 24-106, the Fair Tenant Screening Act of 2021. I wish to thank Chair Member Che for introducing Bill 24-96 and Chairpersons Trayon White, Nadeau, and Gray for co-sponsoring Bill 24-106. And I thank you, Chairperson Bonds, for holding this hearing. I note that I testified on predecessors to these bills last October, so today I am renewing my support for the thrust of these measures, as well as providing further recommendations. I also note that emergency and temporary fairness in renting legislation now in place includes tenant screening and record sealing provisions. This hearing presents opportunities to address issues that have arisen in the implementation of the current law. I ask that the council improve upon the emergency and temporary legislation and enact each of these permanent measures before the temporary legislation expires on October 27th of 2021. Doing so would further promote fairness and racial equity in the way our residents apply for and obtain new housing. The importance of sealing eviction records. The following chart, which is in my testimony, which was part of my testimony for this year's performance oversight hearing, helps illustrate the arbitrariness of maintaining eviction records in perpetuity for every tenant who is sued, even unsuccessfully, for evictions. And as you can see by the record, there are many, many activities that occur when filings happen in the city and then are canceled. So there is a reason why sealing of records is extremely important. And as I say, you can see the data demonstrates that the vast majority of eviction cases do not actually end with an eviction. Yet even the record of an unsuccessful eviction filing can be an albatross around the neck of a prospective renter who could demonstrably be a good tenant. Moreover, the chart above reflects statistics for a year during which there was a moratorium on the filing and execution of evictions for over half the year. Typically, roughly 32,000 eviction actions are filed annually against approximately 18,000 renter households, meaning an eviction record is created on about 1 in 10 renter households in the district each and every year. The stigma of an eviction filing, which often is due to a de minimis one-time arrearage, other non-reoccurring circumstances, or indeed outright errors, should not bedevil district residents forever. Many tenants will undoubtedly continue to experience unprecedented financial turmoil caused by the pandemic for some time to come. And according to estimates made during the fall of 2020, there could be between 20 and 40,000 eviction filings with only the first few months of the moratorium's expiration. If the district were to enact this legislation, it would be following in the footsteps of other jurisdictions that have enacted eviction record sealing laws. Similar laws in California, Colorado, Virginia, and other jurisdictions already provide record sealing protection at minimum where the tenant is the prevailing party in the eviction action. Interestingly, the California law requires record sealing immediately on filing. The record is unsealed only if the tenant does not prevail within 60 days. Our understanding of its purpose is to protect tenants against landlord actions that are frivolous or otherwise readily resolved in the tenant's favor. Bill 24-96, however, goes further than most of the other jurisdictions with record sealing laws by providing for automatic sealing in each and every instance of an eviction action, even when the landlord prevailed after a maximum period of 3 years. This reflects a policy of eventual forgiveness of a tenant against whom an eviction was legally warranted sometime in the past, but who has subsequently maintained a clean record of rental payments for an appropriate period of time. New required eviction notices. I support this new requirement in Bill 24-96 for a 30-day notice of eviction for non-payment of rent for several reasons. First and foremost, it would provide the tenant with a greater opportunity to set the record straight if the non-payment claim has been made in error. The OTA has assisted clients who have faced arrearage claims made in error, and we know that error can be devastating consequences. Second, I support the bill's requirement that for any eviction, the landlord must provide the tenant with a 30-day notice of intent to file the eviction claim. This requirement also makes good sense. As noted, it is often the case that a notice to vacate does not result in the filing of an eviction action. Thus, this notice of intent is imperative so that a tenant is specifically apprised as to the housing provider's intentions and as to his or her own legal jeopardy. I would offer the following recommendations to improve upon this bill. Sealing of pandemic-related eviction records. First, I recommend that the council consider adding to the list of circumstances under which a tenant may move the court to seal an eviction record earlier than the time periods otherwise provided. Under new section 509B of the Rental Housing Act of 1985, where an eviction action for non-payment of rent was solely the result of a tenant's pandemic-related financial hardship, the tenant deserves to have the case qualified for early sealing by motion. Presumption in favor of sealing. Rather than providing that the court may seal an eviction record where the tenant proves any of the circumstances listed in the new section 509B, the legislation should require the court to seal the records in those cases unless there is good cause not to do so. Where a tenant can prove that the eviction was, for example, retaliatory, we should not leave any further ambiguity suggesting that the court still only seal the record. My understanding is that similar language in the current temporary record sealing provision has led the court to apply a multi-factor test to make a further determination whether to seal a record, even after the tenant produces evidence that they have met the criteria for early sealing by motion. The legal hurdle for this determination should be much lower, especially given that the circumstances justifying the 509B motion includes such matters as retaliation, the presence of housing code violations, and incidents of domestic violence. Therefore, there should be a clear rebuttable presumption in law that the court shall seal cases for which there is a successful 509B motion. Allowing access to sealed eviction records for representation purposes. It is important that sealed eviction records remain as inaccessible as possible. However, the committee should consider the needs of tenants and their attorneys in defending their own cases. My understanding is that under the current temporary record sealing law, ambiguity in the language has led the court to consider holding hearings in some cases as to whether a person can access their own eviction record. Such access can be important when, for example, the settlement is reached and the case is sealed, but the defendant is later accused of violating the settlement agreement. In such a case, information in the sealed record can be important for the tenant and legal counsel in defending against the breach allegation and should be made available. Therefore, I appreciate that the proposed permanent version we are discussing today plainly states that the clerk of the court shall provide the record to the defendant upon a written request. The right of the defendant to access their own eviction record should be unambiguous. One last point to consider on accessibility is that tenant attorneys often use language in pleadings and orders from past eviction records in mounting defenses for their clients. It is often the case that a previously used argument was persuasive in a similar case, or that the court ruled in a particular way in the past that would suggest the current defendant should be treated similarly. Implementing new eviction notices. I recommend that the now standard lease clause whereupon the tenant waives the 30-day notice to vacate for non-payment of rent be added to the list of prohibited lease clauses at Section 304 of Title 14 of the District of Columbia Municipal Regulations, DCMR. For the benefit of current tenants, the committee should require a lease addendum or at least notification from the landlord to the tenant that any such waiver clause in an existing lease is nullified. Now I will turn my attention to the Fair Screening Act of 2021. Why fairness matters in the tenant screening process. While the OTA does not typically handle issues involving the tenant screening process, as a denied rental applicant, it is not yet a tenant and therefore falls outside the scope of our representation. It is clear from our conversations with advocate partners and others that too many landlords and tenant screening companies use unfair and irrelevant screening criteria to avoid renting to our most vulnerable residents. This includes, of course, voucher holders, but also tenants with any eviction record, regardless of context. The applicant usually does not know the criteria used for screening an application or the reasons why the application was denied. This can result in needless frustration as well as the depletion of the applicant's scarce resources in terms of both the time and the money it takes to continue submitting applications. Bill 24-106 would help address the inequities in this process by establishing a set of requirements to which landlords must adhere when determining whether to rent to a particular applicant. Importantly, the bill would also prohibit background screening companies from using or considering information that landlords are not allowed to consider. This is crucial as landlords rely on these companies in order to do much of the analysis for them, particularly for large properties where significant numbers of applicants must be processed on an ongoing basis. I believe that addressing the unfairness in tenant screening practices is crucial for achieving racial equity and for affirmatively furthering fair housing. Therefore, I offer my general support for all the components of this legislation, as well as the following recommendations for improvement. And I also welcome continued conversation with the committee as the bill moves forward. First, let's talk about application fees and other upfront fees. In addition to the application fee restrictions provided, the committee should specify that if the applicant is approved, any unused portion of the fee must be applied towards the applicant's security deposit. The purpose of the fee and how it will be applied or returned should be explained to the applicant in writing up front. Conformity. I would suggest that the committee and the council conform certain provisions having conceptual overlap between the two bills. For example, there is inconsistency between the prohibition on looking back more than 2 years at eviction history in Bill 21-106 versus the 3-year record sealing provisions in both the fairness and renting legislation and in Bill 24-96. It would seem to make the most sense that the periods of time for across-the-board record sealing on the one hand and categorical prohibition on looking at past eviction records on the other should be aligned. Placement within the law and enforcement. Although the fairness in renting temporary legislation places the currently effective tenant screening laws in the Rental Housing Act, there are advantages to the approach in B24-106 of placing these provisions in the Human Rights Act of 1977. For one, the Human Rights Act provides for higher penalties, which is appropriate because at the end of the day, the issue this bill addresses are related to unfair discrimination in the provision of a basic human need. Furthermore, these provisions would regulate interactions in which no one is yet a tenant. So this is not so much regulations of a contractual relationship as it is meant to ensure that parties attempting to enter a contract for rental housing in the first place are treated fairly. Furthermore, the Office of Human Rights already handles complaints related to criminal record screening in housing, and so these matters would be appropriate there as well. And finally, I will note that under the Human Rights Act, a denied applicant would likely have a private right of action via the courts outside of the administrative process, providing an additional avenue for relief. Under the Rental Housing Act, however, a private right of action is not necessarily available in all cases, which may leave the tenant with only an administrative grievance process and more time for a denied applicant to respond. As introduced in Bill 24-106, it only permits a tenant 72 hours to respond to a landlord's denial notice with mitigating circumstances or a factual dispute. The committee should consider extending this time to 5 business days, as some tenants may need to consult a lawyer to prepare their response. This is especially important since under the legislation, a factually sound and well-crafted response may in fact entitle the tenant to rent the next available unit of the type sought. Notification of units that later become available. Where the tenant is entitled to rent the next available unit, the bill does not require the landlord to actually notify the tenant in a timely manner that a suitable unit has become available. The legislation only hints that this is what should happen. Thus, we recommend that the bill be amended to include a specific requirement that the landlord notify the applicant via the applicant's preferred method of communication when the next unit is available in each of the following circumstances. First, the applicant sought a unit of a size or type not immediately available, and the landlord indicates that one will likely become available in the next 30 days or the next 6 months. And 2, a denied applicant submits a response to the landlord's denial notice that sufficiently mitigates or corrects the basis on which the applicant was denied. In concluding, Chairperson Vaughn, I wish to thank you for holding this hearing on these important bills. This concludes my testimony, and I am happy to answer any questions you may have at this time.
Thank you very much for your very thorough presentation. I think it raises a few questions that we need to answer. So sounds like we do need to consider all of these, I guess some people would say technicalities, but we still nevertheless would like to have a bill that is not only doable, but one that will work to remedy some of the situations that we've heard a lot about today. So I really do appreciate your testimony. I did not have an opportunity to print out your testimonies, but I will print it out. I was making rapid notes as you were expounding there. So we would like to be in touch with you on a number of issues. So I'm looking forward to doing that as always. And thank you so very much for being here with us. I think it was a very short notice, but thank you.
Yes,
it's
ma'am.
Budget season. I hope everyone understands, and we're trying to really get as much done as we possibly can in a very thoughtful way, of course.
Yes.
So thank you very, very much for your input.
Thank you so much for having us.
Yes. Next, we will hear from, let's see, we have a representative. In fact, the Assistant Attorney General, Kate Velach, and I want to swear you in now. She is with our Attorney General's office. Okay. All right. Do you swear and affirm that your testimony and any statements that you make before us today to be truthful and complete?
I do.
All right. Thank you. And thank you also for being here. We really appreciate it. And we're
Thank
looking
you.
forward to your testimony. So when you're ready, you can begin.
Thank you. And I appreciate you and all of those who've testified before. It has been a very informative day. So good afternoon, Chairperson Bonds, staff, and residents of the district. My name is Kate Velach, and I have the privilege of serving as an attorney in the Office of Attorney General for the District of Columbia. I'm pleased to testify on the two bills being considered today, and I will also say a few brief words at the end about the Eviction Protections and Tenant Screening Amendment Act that the committee will take up next week.
So when is this thing going to expire?
In the interest of time, I'll be sharing an abbreviated set of remarks now and will provide more fulsome written testimony for the record after this hearing. OAG, or the Office of Attorney General, is proud to work alongside the Office of Human Rights and tenant advocate partners to use the Human Rights Act to end all forms of discrimination, including housing discrimination. Over the past year, we have brought 11 housing discrimination cases against 15 defendants, and we also settled a case that required a large housing provider to pay the district $900,000 and implement anti-discrimination policies. Nonetheless, there is more important civil rights work yet to be done, including the work begun in these bills. So with that in mind, let me now turn first to the Fair Tenant Screening Act. Although this bill holistically addresses many discriminatory housing barriers, my focus will be predominantly on barriers related to source of income. Treating someone differently simply because she plans to pay her rent with a voucher is all too common. This type of discrimination is also race and sex discrimination, given that more than 90% of the district's housing choice voucher holders are Black, and that 83% of households in the voucher program are led by women. So by fighting source of income discrimination, we are helping to reverse racial and gender inequality, tackling patterns of segregation, and helping to ensure that all families have access to decent housing. That is why the Attorney General supports the Fair Tenant Screening Act's prohibition on considering voucher holders' incomes and credit scores. Although housing providers need to assess unsubsidized tenants' ability to pay, voucher holders' rent calculations already ensure that their income will cover their rent contribution. Second-guessing this determination only opens the door for discrimination. We also commend the bill's prohibition on extraneous application fees, which serve as an end run around discrimination protections by shutting voucher holders out of housing. We would recommend that the bill go even further by requiring landlords to allow DCHA to conduct the housing inspections necessary to approve a voucher holder's application. But ultimately, having a law on the books is not enough. Enforcement matters. Laws in this sphere must allow for pattern or practice enforcement so that residents are not solely responsible for enforcing these protections on an individual level. Our office has worked with tenant advocates to develop a robust enforcement mechanism, including clear OAG enforcement authority and enhanced fines for patterns and practice of discrimination. And we hope that the council will incorporate this amendment into the bill as it moves through markup. Be happy to share that with you after the hearing. I will now turn to the anti-discrimination benefits of the protections proposed in the eviction ceiling bill. Eviction ceiling is an important piece of the civil rights puzzle because evictions disproportionately burden tenants of color and female-headed households. And evictions, as we've heard throughout the day, can permanently hinder access to safe and affordable housing for vulnerable groups. Ceiling is especially important to remove the stigma of wrongfully filed evictions or filings that no longer reflect a tenant's circumstances. For instance, even though district law bars evicting domestic violence survivors, one study showed that as many as 83% of landlords file to evict survivors who seek police protection. Tenants like these must have the opportunity to clear their record of filings that clearly contravene public policy. Further, old eviction records do not necessarily tell us much about a tenant's current ability to pay rent. This is especially true for voucher holders. An eviction that predates a tenant's voucher enrollment does not reflect that tenant's newly subsidized payment arrangement. We have also come across landlords who have filed to evict voucher holders when it is the district's portion of the rental payment that is delayed, and filings based on the housing agency's delinquency should not mar these tenants' rental records.
OAG supports the sealing of eviction records so long as necessary information remains available for public interest purposes. Given the importance of tracking eviction trends, we suggest adding mechanisms for disclosing certain records and for releasing de-identified aggregate data. We point you towards a model disclosure provision in our written testimony. Finally, a few words about the eviction protection bill that will be taken up next week. As we know, this would make permanent the district's now temporary ban on eviction suits against tenants who owe less than $600. This $600 threshold offers a critical safeguard for seniors and tenants with disabilities who more often live in lower rent subsidized housing or rent controlled housing. It would be helpful for the bill to put both tenants and landlords on notice by clarifying that landlords may still file suit for rent owed rather than for possession of the unit in small claims court. Further, we appreciate the requirement of a business license to sue for rent because this is very helpful to OAG's enforcement work as it provides information that allows us to enforce both housing and property maintenance codes. So in conclusion, I would like to thank the committee for considering these bills, which will make major strides in alleviating housing barriers that disproportionately harm tenants of color, female-headed households, older residents, and persons with disabilities. We at OAG are, as always, thankful for the council's enduring efforts to ensure equal treatment of the people of the district, and I would be happy to answer any questions you may have.
Oh, thank you very much for your testimony. I just have a couple of questions about the two bills that we were reviewing today. Does adding the sealed eviction records to the list of protected classes under the Human Rights Act meaningfully assist applicants for rental housing with eviction records?
Well, our hope is that all landlords are already complying with the provisions of the Human Rights Act. And so by putting landlords on notice of their civil rights obligations in advance, we would hope that that would change or improve the application experience of any prospective tenant. We also know, right, that sometimes you can't prevent something on the front end, you have to respond to it with enforcement on the back end. And having additional protected traits would assist us in responding more fully if we see systemic discrimination on the basis such as eviction ceilings.
Thank you. As you were speaking, I was thinking, if this may sound a little hokey in that I wondered if we know that the landlords file every other year with the DCRA a per unit filing fee. And I wondered if at that time that they complete the electronic filing, if we had a pop-up in the system that would remind them against discrimination, if you think that would be of assistance in the process.
You know, we are always looking for creative ways to ensure that folks are informed of their civil rights obligations and protections so that we don't end up with cases that have to go to court. We know that there are requirements for semi-annual fair housing trainings associated with licensing regulations, and any additional opportunities such as the one you proposed would be welcome. So we would be happy to talk with you about all of the creative ways that we can keep folks informed about their civil rights obligations.
Thank you. I was just thinking, you know, this is the age of notification, you know, so many ads, and I figured, well, why not take advantage of the systems that we have that are required systems and bring home the issue and the requirements that we expect from our vendors. So thank you very much. I appreciate that. Just a question about, I think you kind of answered this, but I want to make sure that I got it. What is your office's role in addressing violations of the Human Rights Act as it relates to tenants, as it relates to gender equality? Trying to think about that in particular.
Sure. So our civil rights section enforces the Human Rights Act at a broad level. We have responded to pattern and practices of discrimination in housing, largely connected to source of income, so being a voucher holder. But we have also brought claims under the Human Rights Act for discrimination in housing on the basis of race, as well as ethnicity. So we certainly could bring a claim for gender, as you mentioned, if the facts presented themselves. But we have been partnering with the Office of Human Rights to ensure that we have holistic enforcement of the Human Rights Act, both at the individual level and at the broad pattern and practice level.
You know, it just seems, thank you for that answer, but it just seems that that is an area, a gender equality or non-discrimination because of gender is a very important arena, and particularly in the District of Columbia. So I just wondered, you know, if that's something we really need to look more closely at and make sure that there is language within these bills that address that issue. So if you would look closely at it and provide us with some advice, I would greatly appreciate it. I think it would be worth it.
Absolutely. Thank you.
So that really concludes the questions that I have. Thank you very, very much for your testimony. I know it's been a long day for everyone. I would like to get back to, so thank you very much, Ms. Bullock. Thank you. I would like to get back to Holly Donaldson, and I just had a couple of questions. I think you kind of answered this, but I want to make sure that I'm clear. How do you see your agency's role in expanding and this is beyond the FTEs we kind of alluded to, expanding if the Evictions Record Sealing Authority Amendment Act were passed into law permanently?
Sorry, someone just came in the office.
Oh, I'm so sorry.
No, that's all right. I'm here. I'm sorry. Could you repeat the last part of that question?
Yes, want to make sure that I understand what you see that your agency's role in expanding the Eviction Record Sealing Authority Amendment Act if it becomes permanent law.
Yeah, no, I think our role is not only in implementing and receiving information, but in also doing outreach and public information on the rights of additional rights of tenants. That's what our Housing Resource Center does. I think we've used this time during the pandemic to think about how better to expand beyond just an on-site, but also through electronic communications and social media, and to really be part of the information source, or one of the information sources, together with my colleagues at OAG and OTA, about really understanding what are the rights of tenants, what are the responsibilities and the rights for both tenants and housing providers. And that's really our role. It's really, I think, one that we can do even more robustly and take advantage of the fact that where there are changes in the law, that you know, that's part of our responsibility to communicate that and to make sure that residents know about that. I also think that we can, you know, do more on mitigation so that we, you know, prevent, you know, eviction. I mean, I think some of the lessons that we're learning from some of the rent assistance programs that we have put together over the last year is that there are some strategic ways to reach tenants and housing providers, and that there have to be some ways that they collaborate, communicate, and mitigate together. And so that's something as well. I will also say the data collection, which I know several researchers, some of the policy folks spoke to this over the course of testimony. We have some the ability, I think, to do even more analysis. And once we get the database and can really be able to register everyone and run the reports, I think that's going to be, again, a very important source of fact of what's really happening with tenants, with the whole rental housing market. This is just such a great opportunity that I really want to encourage the committee to look at in its holistic, systemic way.
Well, I appreciate that that comment. Quite honestly, I'm thinking that from the pandemic and the rental assistance program that we're putting in place now, seems to me one of the lessons for our city is that we must do everything we can to keep people in their homes. If they want to make it their home, we should be working with them to make it their home. And so evictions, as a rule of thumb, should be very, very limited. I'm trying to remember the mayor saying about homelessness, seldom reoccurring or something to that effect. We really should make sure that that is the case.
Right. Rare, brief, and non-reoccurring.
Yes, exactly.
Right.
Because
I think that's similar. I mean, that really ties it's the housing system in the district, which includes our homeless housing system and our eviction prevention. Some of the witnesses today talking about their experiences with rapid rehousing and permanent supportive housing. I mean, I think all of this integrates in together. And, the one benefit of and one of the reasons I'm advocating strongly for this to be changes to the Rental Housing Act or additions to the Rental Housing Act versus the Human Rights Act is in order to really have it more efficiently streamlined and consolidated together in the Housing Regulation Administration and under the Rent Administrator. I mean, I think that really will be helpful, especially once we have the database as well.
So you actually see the two bills giving us an opportunity to make changes in the Rental Housing Act per se.
Well, the strong urging and recommendation from the administration, from the Bowser administration is, and this is in consultation with the Office on Human Rights, this is not unilateral, and they're very happy to work with you on this too, that the changes being recommended administratively should be consolidated under the Rent Administrator and the Housing Regulations Administration that's housed in DHCD. And so that would mean amending the Rental Housing Act versus the Human Rights Act. That does not prevent OHR from taking any action whatsoever, because it's still a protected, if it's added to the Human Rights Act to make it a protected trait, it will, that's enough. That's all they need to be able to then proceed with their work on discriminatory actions as well. So, but in terms of the day-to-day housing provider, landlord-tenant relationship, rights of tenants, et cetera, I think that, that is better housed within DHCD and within the Rental Housing Act specifically.
All right, well, thank you for that comment. Thank you all very much. Staff, have we covered our agenda?
Yes, the entire thing.
Okay, thank you. As you all can see, I don't have the team here and we're doing everything virtually. So you get to witness our background discussion, so to speak. But I want to thank everyone who testified today. I think Director Donaldson put her finger on the proceedings that we experienced today. Very telling, and I think it draws us closer as a community, understanding that there is no M, Q, A, B, different pieces, that they all must fit together, and they're very related to each other when we talk about housing and the will to continue to live in the District of Columbia. So I want to thank everyone again and thank my colleagues. I'm imagine that some are listening. So in thanking everyone, I want to announce that the committee's next meeting will be on Tuesday, May 25th, 2021 at 10 a.m. And it's a public hearing on Bill 24-119, the Eviction Protections and Tenant Screening Amendment Act of 2021. And with that, I can say that we are just a few minutes past 5. It's 5:02 p.m. And so our meeting is adjourned. And again, thank you to everyone that helped us through this process today.
Thank you, council member. Thank you.